Now, hello and welcome to all. My name is Chetna Kaushik, and I welcome you to today's event. We would like to start by thanking our sponsors, Skadden, Denton's Link Legal, Linklaters, A&O Sherman, Baker McKenzie, and ICAM Law Offices. This event is supported by lawwiser.com. Thank you, everyone. Without further ado, the General Accountants Association of India presents today's session with the theme, Rethink, Redefine, Re-evolve the Legal Profession in India. To give the welcome address, I would like to invite on stage Dr. Sanjeev Gimawat, founder GCAI, Managing Director and Group General Counsel, SR Group. Welcome, sir.
We were waiting for this day, so I will just say a few words to welcome all of you, our distinguished guests, our esteemed speakers, members of the General Counsel Association of India, and friends. It is my privilege to welcome you to this significant gathering of legal minds and industry leaders at this conference, which is titled as Rethink, Redefine, Re-evolve the Legal Profession in India. This forum is not just a discussion platform. It is a call to action for much needed reforms in our legal profession. India is at the cusp of unprecedented economic growth, with projections placing us among the world's top 3 economies in the coming decades. As our GDP expands, so must our legal framework evolve to support this growth. A robust legal infrastructure is the backbone of any thriving economy, one that ensures regulatory clarity, facilitates ease of doing business, and strengthens investor confidence. However, despite the critical role of legal professionals in corporate governance, compliances, dispute resolution, our legal framework has not kept pace with changing economic realities. The legal services sector, as a percentage of GDP, remains significantly smaller in India than in developed markets such as the US and UK. In those jurisdictions, legal services contribute approximately 1.5 to 2% of GDP, while in India it remains below 0.5%. This gap is not just statistics. It is a missed opportunity for economic and professional expansion. With India's increasing global integration, the demand for specialized non-litigation legal services is growing. Yet our legal framework remains narrowly focused on litigation and court advocacy, a model that is nearly 7 decades old and increasingly obsolete. Professions evolve based on societal needs, and it is time for legal practice in India to move beyond its traditional litigation-centric structure. Our legal ecosystem must recognize the reality that law is practiced not just in courts, but across boardrooms, regulatory agencies, international trade negotiations, and corporate compliance functions. The outdated distinction between practicing advocates and in-house counsels is stifling the natural evolution of the profession. Consider this, India has estimated, can you believe this? India has an estimated 2.5 lakhs to 3 lakhs in-house counsels or general counsels who are serving as legal advisors to businesses across industries, yet they remain outside the purview of any regulatory framework. More concerning is the fact that they are not even legally recognized as practicing legal professionals. This is a glaring anomaly. These professionals, despite holding law degrees recognized by the Bar Council of India, are required to surrender their sanad, which is the practicing license, and are excluded from the legal fraternity. This lack of recognition not only undermines their contributions, but also limits their ability to provide holistic legal support to businesses in an increasingly complex regulatory environment. We must ask ourselves, consider a $5 trillion economy, or during this Amrit Kal period, India at 2047, which we are saying $30 trillion economy. Can we afford to ignore such a vital segment of its legal profession? The answer is a resounding no. India's legal landscape requires urgent reform to recognize and regulate the role of in-house counsels, bringing them at par with their global counterparts. This is not just about professional recognition. It is about ensuring that businesses have access to qualified, regulated legal expertise that is essential for navigating the complexities of a modern economy. Today's conference is a step forward that change. Over the next few sessions here, we will engage in critical discussions on the future of the Indian legal market, the evolving responsibilities of general counsels, and the legal reforms needed to integrate in-house counsels within the larger legal framework. Personally, I'm confident that with the esteemed panel of policymakers, jurists, and industry leaders present here today, we will pave the way for progressive reforms that will strengthen the legal profession and contribute to India's economic and business growth. Now, with that, I officially welcome all of you to this conference. Let's rethink, redefine, and re-evolve the legal profession in India and our force together. Thank you very much.
That was definitely a view with a lot of foresight. Thank you so much, Dr. Sanjeev, for your warm welcome address. We will now begin with our first session of the day. What will the Indian legal market look like in the next 10 years? I would like to call upon the speakers of the panel, Sharmishta Chakrabarti, Counsel, Skadden, Arps, Slate, Meager, and Flom LLP. Mini Menon Vandepal, Asia Pacific Head Investigations, Compliance and Ethics Group, Chair of India Practice, Baker McKenzie. Joydeep Sen Gupta, Partner, Denton's Link Legal, Paris. Daksh Aluwalia, Founder and Principal, ICIM Law Offices. Please welcome. And the moderator for this panel, I will call upon the stage our GCAI member, Ami Parekh, General Counsel, Asian Paints.
Hi, guys. Good afternoon. Am I audible? Because I think that's one question we're all now used to asking. So today's panel is going to talk about how the Indian legal market is going to evolve over the next decade. And like Sanjeev rightly said, right, the Indian economy, the growth story of India is not new. You know, we are the fifth largest economy in the world, and we're soon going to be the third largest economy, going ahead of Japan and Germany. India's has seen a massive infrastructural push over the last decade. Since 2014, there's been a 500% in the budget allocation for road transport and highways. India's digital economy, the digital enabling industries contribute grew at a rate of 17.3%, like faster than the Indian economy, and they're expected to contribute 1/5 of the national economy by 2030. India Inc. has been significantly growing its legal spends and the investment in in-house legal teams. The role of the GC has gotten a lot stronger over the last decade, and that is where what Sanjeev rightly said is that we need to be recognized as legal professionals in our own right. the growth of specialized legislation, the introduction of the IBC, the Competition Act, the GST, all of these have really fueled exponential growth for law firms. And I think the growth of the Indian economy is tied so closely to our growth and the evolution of our profession. And that's my first question to Joydeep. What do you see as the impact of this India growth story on the Indian legal market?
Thank you, Annie. Can people hear me? Hi. Thanks again for having us, and it's a pleasure to be on this panel. So in our, briefing discussion sessions, which some of us had with Annie, we talked about this issue, and we went through some of the numbers. And I think, those have been mentioned already. It'd be useful, to just kind of remind ourselves what those numbers are. India is now the fifth largest economy after the US, China, Japan, and Germany, having already surpassed the UK, France, Italy, and Brazil. So it's already at that level. You have an economy which is increasingly integrated with the global economy, which wasn't the case at this level, maybe even 10 years ago, right? And that has been partly due to a very favorable foreign investment structure and important legal reforms that have allowed that investment. But when you're sending in that investment from whichever jurisdiction you're coming from as a foreign investor, you want to be assured that the legal system protects your rights. And it's comparable to what you're used to in similar sized economies. So when you look at the Indian economy and you look at the number of practicing lawyers, and I think Sanjeev mentioned, it's 1.5 million practicing lawyers under the Bar Council, but on top of that, you also have all of the in-house counsel that are highly experienced, that are at the cutting edge of business, that are sitting in the boardrooms, that are making decisions and managing risk around the world, but they're not considered part of the legal profession. This is not the case in the other similarly sized legal economies, large economies like the US and the UK. I'll give you an example. So I'm based in Paris, and one of the reasons I moved to Paris was because French in-house lawyers did not have legal privilege. So I was based in New York, I was New York qualified, and there was a big investigation going on at one of my big clients, and they needed to have that investigation run out of France by US qualified lawyers so that everything would be privileged. And it tripled the cost for the client. They could have handled a lot of that work in-house, but the French legal system did not allow it. Today, in 2024, France introduced legislation recognizing potential legal privilege. What have they done? They're trying to limit it to a very circumscribed area in which privilege would operate. Those kinds of reforms are necessary when you look at the size of this economy. France, I'll give you another example of extraterritoriality. France right now is I think the 13th largest, or the 11th largest foreign investor in India, okay? And it's $13 billion invested in every major area of the economy. So you're looking at cosmetics, you're looking at luxury, you're looking at defense, aviation. I'm looking at Lubinisha. And all of these sectors are growing. And French laws, like Sapin 2 in France, which is an anti-corruption law, applies to every French company globally that has more than 500 employees and over $100 million of turnover. So if you're an Indian subsidiary of a foreign company, Indian subsidiary of a French company, all of those obligations apply to you in India. And if your in-house counsel cannot manage a lot of those risks with privilege, it adds costs and burdens on the clients. So I've talked a lot, so I'll stop and give others a chance.
So thanks, George. It's interesting to hear that there are councils, there are in-house professionals that have the same recognition in other jurisdictions, and we're hoping to get there one day. So Daksh, this is for you. As India aims to climb the global order, right? What kind of changes do you think that the regulatory and the legislative environment will need to facilitate that rise?
Thank you very much for bringing me on the panel. Really appreciate the opportunity for putting everything together. Yes, so there are, of course, things that have been done in the last 10, 20 years which have, furthered the single window clearance and making it easier from a regulatory perspective or legislative perspective. There's a new Companies Act in India. There are various laws that are changing on a daily basis. But of course, in a country as large as India, as complex as India, there are more things that can be done. On the regulatory side, you have the labor codes that ought to be implemented soon. You've got the data protection laws that ought to be implemented soon. And there has to be a will within the government to do that. More so, I think, where the change really needs to come in and which may resonate with a lot of the general counsels here is on the judicial side. You have, a judicial system, which I was hearing a podcast by some of the most eminent lawyers run by Mr. Kapil Sibal a couple of days ago, and they said that the judicial system is crumbling. And there are serious issues, and I'll say that before the law minister comes in, serious issues on the judicial side. And I think the changes that need to be made are threefold. First is every person who is approaching courts or is involved in the court system needs to have faith in the court system. So you need to believe that the judges are competent to decide your cases, whether that's in a tech-driven world and the judges are unbiased. So when you talk about competence, you need to have judges who understand what is going on in commercial issues, what is going on in technology, what is going on in business, and those are the kind of issues that need to be resolved fairly quickly. The second thing is certainty of outcomes. Certainty of outcomes. We had, I was at London Disputes Week last year, Dubai Disputes Week last year, and all people talked about was the DMRC judgment. At the 5th round of judicial review, the judgment is set aside in a curative by the Supreme Court. Now, it's immaterial to talk about whether the decision is correct or incorrect. It doesn't matter. What matters is you have different levels of judicial oversight into arbitral awards, and at the 5th level, it is being set aside. And I think, respectfully, it's just wrong because it gives no certainty to somebody who's investing in the country as to what's going to happen. We had two very prominent Hada cases. One was an Anil Hada case and an Anita Hada case. And some of the Indian lawyers here may know about it. In 2000, the Supreme Court gives one decision on check bouncing cases. And in 2012, there's a completely different decision that sets it aside. So you have 12 years of reliance being placed on a particular Supreme Court judgment, which is eventually overturned. And that creates a lot of litigation and complexities in the court system. And the third thing I think which is very important is to bring in very immediately the loser pays principle. The senior counsels today are charging $20,000 a hearing, but if you award costs, even if you get to that point where costs are going to be awarded, you won't even get 20,000 rupees per hearing. So you have to bring in those judicial legislative changes to bring about that change for really bringing India on the global map.
And when you talk about, when both of you talked about, the investor confidence that we need to build in, right? A lot of the laws that we're bringing in, like if you look at the data privacy rules the draft rules that have come in, right? They're fairly vague. It's going to be really hard for Indian companies to implement something. And I think the government cannot now look at the law as a checkpoint. This is something that we need to do to show ease of doing business in India, but this has to be law that can be interpreted and implemented effectively by companies. So I think that sort of better legislation making, I think it's a work in progress. You see it in some parts, but in most parts you don't see that. Or you see a law sitting there for so long, and by the time it's actually put into place, the world has moved ahead. So I think those kind of things we'll have to see. But yeah, Mani, did you have a point here?
I just grabbed the microphone anyway, but thank you.
I sorry I put you on the spot.
I'll always have a point there. No, I think that's they're all really good points in terms of particularly in terms of these new regulatory changes, and the data privacy law is a good example. We don't need to reinvent the wheel, right? So there are lots of these types of laws that have to be implemented in order to protect data, protect information, and allow business to have some confidence in terms of global best practices. So, I think we need to move away from just India and think about ourselves, and Indian companies are doing that in leaps and bounds as global companies, as leading multinational companies in their own right, who want that certainty. They want to know that if they have to comply with GDPR, there's going to be support here in India in terms of similar structures and processes in place. So, I also appreciate being invited to this panel. I was actually very excited because, for us as a global law firm, Baker McKenzie we've been working in India for the last sort of 60 years. We still are not able to have an office here yet, but I'm hoping that all of you will lobby to support us in that event. But it's all part of the same story, right? Because what we want is we recognise General Counsel have an extraordinary important part to play within business. You are, the trusted advisors of the board, of the C-suite, and therefore there needs to be protection to the advice you give, just in the same way as there is to the advice that external counsel give. And what I'm seeing is there are a lot of companies, non-Indian companies, wanting to hub their regional legal team in India. But one of the things that holds them back is in relation to ensuring that the General Counsel and their in-house lawyers have the benefit of privilege. So I think it is now time, Sanjeev, I think you said it beautifully, in that if not now, when, right? We need to move ahead. Clients are demanding it. You are our clients. And we need to support the evolution, because otherwise this will hold India back in a way that will impact business.
And so we've talked about the legislative environment, and we talk about the role of GCs. How do you see practitioners, right, having to now sort of adapt to evolve, to meet client expectations? What kind of best practices you think that we can take? All of your global law firms, what kind of best practices can practitioners, law firms take from all of you to better serve the Indian client, right? Because I think the growth of the legal professional is in both ways. So maybe we can talk a little bit about that.
So one of the things that I see, I was on a panel with a number of external counsel in India, and one of the things that came up is the demand that clients are putting on us to be practical, to give recommendations, to basically put skin in the game in terms of partnering with our clients in terms of their business needs. And the partner from the Indian law firm said, oh, well, we don't do that because we could get sued. And I thought, well, yes, that is correct. We too know that there is a risk of legal liability if we get it wrong. But I think that's part of the reason why we do need to think of it in a global context, because these days getting a piece of advice, which is 20 pages long, full of terrific footnotes and annotations and case references, no GC has time to read that, frankly. I had a client who said, if I can't see the nub of the advice on the front page of my iPhone, then I'm not going to read it. This is the demand. You guys haven't got time to sift through that. What you want is your legal partner to provide you with that commercial, practical advice with recommendations. You may not follow it, but with recommendations and with an understanding of their business. And I think that looking at legal practice from a lens of global business is probably the best way to go about that. And I think that's where the sector will need to move. And frankly, with the advent of AI, and I know we're going to talk about that, the whole practice of law is changing, and it will change dramatically over the next 10 years. So we need to keep a pace of it. Nobody has time for 10 lawyers to attend a call and charge for 10 lawyers. People want things that are quick, practical, and knowledgeable. They want you to know their sector and industry intimately. They want you to know their business, and they want you to be aware of their strategic direction. So I think all of that means that, one, the GCs need to have a seat at the table and be recognized as such. And then as external counsel, we need to be supporting and partnering.
Yeah. So just to pick up on what Minnie was saying, the other topic that I think we had discussed was, why is this reform necessary? And one, we talked, yes, the size of the economy is growing, so what? But the legal systems are interacting more and more, so what? Well, there's unfair advantages of some legal systems, and I'll point to the US, if we're honest, right? Because it's the biggest economy in the world, it's the biggest legal market in the world, and it's the biggest extraterritorial enforcer. So if you look at, in the last year, for instance, right, you had the DOJ indicted with the Adani case, right? Then you had 19 Indian companies that were that faced secondary sanctions from the US for business that from the perspective of the Indian businesses, they didn't understand why they should be subject to US law. Because you had an Indian company doing business in rubles or rupees with Russian companies subject to Indian law, and the US is coming after them. What's the US nexus, right? So to confront that, if the GC of the US company, all of their advice is legally protected, but the Indian company is not, that's a disadvantage. So I'll stop there.
So, Sharvish, I just wanted to pull you in on this question, right? When we were discussing, we were talking about how clients expect you to handle sort of multiple jurisdictions and make sure you have similar placed advice everywhere so that the approach is similar. So maybe you can talk a little bit about those best practices, right? Because again, this is something where the Indian legal practitioner will also have to evolve, because today, when India sort of moves ahead and invests more, today you always need a foreign sort of law firm partner, and sometimes that foreign law firm has to interpret the advice for the Indian law firm. So maybe just a little bit about that conversation.
Well, first of all, again, I echo what everyone else has said. Thank you so much for having us, having foreign law firms here today. It's really invaluable for us to be able to meet the GCs, our clients, at a conference like this. And with that, Ami's question, I think, is really quite appropriate, because that is where firms like ours often come in. When you have companies like the companies you represent, you have operations all over the world, and you are the Indian GC or the APAC GC sitting here in India. But you're also coordinating with your US GC, you're coordinating with your Asian counterparts, you're coordinating with your Australian counterparts. And an organization really is like an octopus. It has tentacles. And you have to make sure when you're having a global proceeding going on that each tentacle is very well coordinated and it's dancing the same dance. Otherwise, you'll get crossed, and you'll have your Indian lawyers saying something to the Indian CCI, the competition authority. We'll have somebody else saying something else to the DOJ in the US. And that's really where we sometimes come in, to make sure that the left hand is seeing what the right hand is saying, and the response is coordinated. And that's really where the GCs play a very important role. And as Joydeep just mentioned, if the US GC's conversations are protected, but the Indian GC's conversations are not, you have this really bad sort of a gap, an arbitrage, which is great for the regulators, but guess what? It's terrible for the company. And so that's where we really come in and we try and help and advise our clients.
As we talk about global, best practices at global law firms, really any conversation about the Indian legal market is incomplete without looking at the impact of technology and AI and how it's going to hit us in a big way. So what I wanted to ask you, Sharmishta, was what does the role of tech or AI play in your law firm, in your practice today, in your markets? And where do you think, maybe the Indian law firms or the Indian legal practice is comparatively? So, like how much do we have to catch up? So maybe you could just tell us about that.
Yeah, I'd love to talk about that, especially since the headlines everywhere today is about DeepSeek and how China has gotten there in a quarter of the price that OpenAI took to develop ChatGPT. It's really a hot topic. And when you talk about AI or artificial intelligence, it's really a very large concept. within that concept of AI, you also have simple things like autocorrect. That is also AI, just correcting your spelling. But what is people are talking about today more and more in the legal market is this concept of large legal models, or LLMs. And ChatGPT is an example of an LLM. And what does an LLM do? These are AI tools that are trained on large data sets. And in the legal market, what we're seeing, especially in the US, is that you have specialized companies like CoCounsel and Harvey that are coming in with AI tools tailored to help law firms. Question then is my job irrelevant? Can a computer do what I've been trained for 15 years to do? And I'm treating that as a joke, and it is laughable today, but the reality is we need to harness AI before AI takes over us. When ChatGPT 4 came in March of 2023, no, of course, please. Yes, sir. Just picking up the conversation, when ChatGPT 4 was introduced in 2023, so just about 2 years ago, lawyers in New York were very excited. Like, this is great. You know, you can type in a question and you'll get an answer, and you'll get a case citation as well. And one of these very excited lawyers filed a brief in the Southern District of New York with a number of citations. It was a question he got last night, and in the morning, the brief was before the judge, wonderfully cited, blue booked, perfect. And then the judge sends the brief to his clerk and says, "Can you please take a look at these cases?" I kid you not. 3 of those cases did not even exist. And that attorney was sanctioned. So the moral of the story really is that, yes, the AI tools are there, but it has not yet reached the place where it can take over my job. And my job is to be responsible and check what ChatGPT is doing. Another word of caution. At Skadden, for example, we will never use ChatGPT. Why? Because confidentiality is a huge issue. We will never put confidential client information into an AI model. Why? Because as I said in the beginning, LLMs learn by trawling through data. So the moment you put in confidential information, it is there forever. So which is why CoCounsel and Harvey and all of these new programs which are being trialed, when you sign up to their user agreements, they will give you confirmation that they're not going to be storing your client's data. All this to say, I think AI is really a tool that needs to be used, but it has to be used, at least today, with several guardrails in place to make sure your confidential information is protected, to make sure you're not getting inaccurate advice, which is why the human, at least today, is still relevant.
Yeah, I think very soon, you know, you have a Google doctor already. We're going to have Google lawyers very soon. You know, I won't be surprised. And you may find some clients also coming to you saying, you know, we've seen this is the position of law. And I don't know if other GCs face this, but my business guy is often doing a Google search while asking me a question saying, I think this is what the law is saying. So, you know, I think I can go ahead and do this. And then we'll be like, you know what, just hold it right there. So, yeah, you know, anybody else, you know, what kind of technology do you use in your practices? I'm going to throw this question open to the panel. I think this deserves a lot of attention.
So we've been investing in AI tools for nearly a decade now because, well, partly because clients are demanding it, but also partly to protect client data. Just exactly what Shamista said. You know, we can't use programs like ChatGPT, but we can't not use programs to create efficiencies and to provide more streamlined services for clients. So we've actually invested in AI tools for 2 reasons. One is to protect in terms of privacy and confidentiality, and also cybersecurity, because cybersecurity is a big threat and no less a threat to law firms as it is to yourselves and your businesses. And the second is in terms of creating efficiencies to save time and, more importantly, money. Clients know that these tools exist. They're not going to sit around and wait for a joint venture agreement to be drafted from scratch to take into account their requirements. They want speed, they want efficiency, and they want good, clear, practical drafting. So we've invested in tools that will support the lawyers. And I think that's really the key, is supporting legal practice. Doesn't mean that a number of our jobs might not exist in 10 years' time, perhaps. But I think the legal skill and input is not going to go away. But we're going to be leaner. We're already having to be leaner. So therefore, I don't think we can kid ourselves that we're going to look exactly the same, behave exactly the same, charge exactly the same as we do now in 10 years' time. And I think the tools that AI provide will assist us in making sure that we can do it in a way that makes sense for our business, because we too run a business. So I think it's quite exciting in terms of what AI is going to bring to legal practice. Now, it is going to have perhaps a larger impact in terms of India, where obviously, as you all know, many companies have put in legal teams, contract drafting, diligence, lawyers, multi-billion-dollar corporations have put their legal services to support their business in India. Now, that is going to change. I think AI tools will mean that those kinds of research and input can be probably done with less human requirements. So I think, you know, things will look a lot different, but I think we need to keep updated, and we need to support the way that business appreciates legal input in a true sense, not just the grunt work, not just the get somebody to draft a contract, don't you have one off the shelf, but in fact values real legal input. And I think that that's probably going to be the exciting part of AI taking away some of that grunt work.
Yeah. As I think it's been said many times over, but I'll say it once again, AI will probably not replace lawyers, but AI-enabled lawyers, or lawyers who use AI, will replace other lawyers, you know, potentially. But I think where we really see today, where it's being used very effectively within in-house teams, within law firms, without going into whether it's ChatGPT or proprietary or Harvey or, you know, whichever different models are out there, the first draft, the first level of information, I think that's become very easy to procure. Whether you're looking at case laws from an Indian context or a US context or a British context, you want a case summary, you don't have to have a first year associate, second year associate drafted up for you. You can rely on what's written in the AI output, and then just review it, and then go to the actual case and then compare it. Just entering new markets from the GC's perspective, what we've seen, you know, GCs around the world will look at entering new markets, looking at new business models. When they have to evaluate, they don't always have the ability to engage external counsels for it in different jurisdictions. Maybe they need quick inputs, so they can just go on and get some preliminary information, and then it's always subject to, you know, verification from expert counsel. So those are the areas, I think, where it's really effective, and I think it's only progressing in a good way, in a good direction.
To share very quickly on the Denton side, so we, like, you know, Baker and Skadden, we're a very large law firm. So we have almost 12,000 lawyers all over the world in almost 80 countries. So it's difficult to take a single approach. So what we've done is taken a very regional approach. So we have a different approach in the US, different approach in continental Europe, UK, and Asia, partly because of these confidentiality rules and the risks. So the GDPR violations are very highly penalized in Europe. So we've taken a much more conservative approach in Europe. And just as Sharmishta said, and same with Minnie, we have off-the-shelf products within the constraints. But one thing that has worked is in some very targeted areas, we've partnered with the clients to come up with targeted products. So give you one example, and so I lead the compliance and investigations practice in Paris. So we targeted, it's public, so we targeted with Société Générale, which is a big French bank, in creating a tool, an AI-led tool, which was comparing regulatory enforcement actions from various regulators. So you have case law summaries, but you didn't have a single database where you could compare regulatory enforcement across multiple jurisdictions or for the same regulator. So something like that, which again would cost hundreds of hours of a junior associate making comparison tables, is a good example of things that are much more targeted and focused, but using open source data.
I think when we were discussing, I think something that we also spoke about is how clients approach you to understand how they can better use tech in their own in-house legal teams, right? Today, as India Inc. is investing in lawyers, they want tech-savvy lawyers. So there's a lot of push to make sure that you are using technology or digitization or automation in some way or the other to sort of reduce the external legal spend and to make yourself more efficient. And I think for GCs, given the close tie-up with business, there's a lot of data insights that technology will throw up. Like if I'm looking at, say, consumer complaints, or I'm looking at any kind of litigation, if I'm able to show a trend in what kind of services or products there are certain kind of issues, I can pass that on to my business. And I think that sort of gives a value add to in-house lawyers, the whole the data analysis piece of it, right? I think that's going to give an edge, not just purely legal work, but also other things where you can enable business, right? So I think we'd spoken about you saying that you have clients who look for consultancy also on what kind of tech they should be bringing into their this. Yeah, sorry.
No, I was just going to say, one of the big areas is in terms of tax. So we definitely have worked with clients to utilize their data across their global network in order to better streamline their tax structuring. And AI tools have been a game changer in terms of being able to deal with the big data. IP is another area where obviously maintaining your trademark and copyright information, your patents and the like across multiple jurisdictions, across multiple regulatory frameworks, these types of tools have made in-house legal teams much more effective and streamlined, and frankly, they rely less on external counsel. So I do think that this is a pressure point that's coming from all directions. But again, you don't want to be sitting there having to do a survey, just as Joydeep says, internally, if you can't sort of support external counsel to do it, you don't want your team to be sitting there looking at regulations across multiple jurisdictions, because it's just not efficient. Also, your young lawyers don't want to be doing that. Our young lawyers don't want to be doing that. So, we want to make sure that from a legal career and development perspective, that we focus our young talent on the things that matter. Right? Both your team as well as ours. We want to keep them challenged. We want them to feel engaged. We lose too many young people out of the legal profession, both in-house and external. So what we need to do is make sure that we provide them with challenging opportunities, and opportunities which allow them to develop and evolve and expand their horizons.
Yeah, I think there's another panel that we have some, educational institutions coming, and I think how young lawyers are trained, right? The kind of training we've received, and the kind of grind that we've seen. I think the practitioners, the future lawyers for the Indian legal market, have to be trained very differently. And I see that we have sort of gone past the allotted time, but I think there's a separate panel required for tech and AI and Indian legal market. So hopefully we'll get there someday.
I absolutely agree. Thank you so much, and especially thank you all of you on the panel. As Sharmisha said, someone working with the DeepSeek tool, I completely agree. Miss Minnie, you should be stationed in India very soon. With that, I would like to thank all the speakers for the spirited discussion. We would like to present a memento of appreciation to our panelists. To present the memento, I would like to invite C.V. Raghu, founder GCAI, former Group General Counsel, Global Responsibility, Samvardhana Motherson Group. I would also request the panelists to please stay for a photograph. Thank you, everyone. I would now like to call upon Sri Subhash Chandra Garg, former Finance Secretary and former Economic Affairs Secretary of India, who also served as an Executive Director at the World Bank. Sri Subhash Chandra Garg has made several significant contributions to India's economic policy, such as GST, fiscal responsibility, infrastructure development, and other financial sector reforms, which have had a lasting impact on India's economic landscape, promoting growth, stability, and transparency. Sri Garg will address us on his experiences in developing effective regulatory framework for the keynote address. Welcome, sir.
Very good afternoon. Very nice to be with you on a day when the main focus of attention is on economic survey and the budget. I think you're sitting together to discuss fundamental issues connected with the legal profession and aiming to do something very massive, rethinking, redefining, and re-evolving the legal profession in India. So let me give you my take of where things are, and I assume all of you, or most of you, are working with the corporates. That is where the legal profession which you are most concerned would probably be aiming at. So in my judgment, and I assume we'll have half an hour, right? 15-20 minutes, and then, right, and we'll have some session for question answer, or, right, so, right, because I will try to restrict my comments to 15 minutes to, right, okay. So that is where, so the way I see the corporate related legal challenges and the legal situation, I think there are three fundamental or three kinds of law, or the challenges if you want to put it that way. There is a fundamental set of laws, the constitutional, the fundamental laws which define how the businesses and the industry can be run, governed, otherwise. And those fundamental laws will, let us say, define whether you are in a country where the system permits private enterprise, or is it a very socialistic, communist kind of country? Do you have major private system operating in that country, or you have largely a public sector? Those are the fundamental. Do you operate on a system where foreign investment is permitted, or the foreign investment is not permitted? It's largely a domestic economy or not? It's a competitive based kind of system, or more of administered. So these are the fundamental which decides how the industry sets up, how it grows. Then I think the other set comes, the next layer. The next layer is the ecosystem laws or the governance laws, which you built upon the fundamental layer. For example, we were we had this system of socialistic pattern of society which was built within that system, and under which we had a lot of license permit kind of arrangements. IDRA was there, where the industry were regulated, capital controls were exercised. How do you sort of set the environmental related laws into operation? So those are the labor laws, factory laws. These are the, to my mind, the governing laws which set the ecosystem for the industry to operate and the corporates to run their business. Then comes to my mind the last layer, the major layer which we on day-to-day basis probably interact with. That is how the industry is regulated, what kind of returns you file, what compliances you do, in very different kinds of, and when you see in the Indian context, there are very large forms, regulations, compliances which are there. So to my mind, these are the three fundamental or the way, the legal structure which you are faced with. And whenever you think about how do you rethink, redefine, I think that is where one need to. I will bring one more equation into, and then I'll dwell on my further comments. In your role in the corporates, I think there are again three kinds of responsibilities which you primarily have. One, the lowest level of responsibilities to my mind is what we can call reactive responsibilities. So somebody files a case, an employee files a case, or a customer files a case, or a competitor files a case, and then the legal department is supposed to handle them, file replies, go to the and contest that. This is basically reactive. So you react to a situation which gets created by those who feel who have complained or who feel their rights or they have been in a way violated or adversely affected by that. And you react to try to win those cases for you or your company. That's one set of things. The second responsibility, which I think is not still very much realized by the system as such, and the legal people are perhaps not interested in some cases, at least not, if not generally speaking, that is the proactive kind of legal responsibilities. So all the time the legal system, which I said about the fundamental or the ecosystem, those keep on changing. And that puts very different and new kind of responsibilities and requirements on the companies and the corporates to deal with. For example, when the license permit system went out and you had more liberal, or the competition laws comes into the system, or you can raise money from the market by going to them, or the environmental responsibilities or obligations become more strong. You have to abide emissions control or the pollution control and those kind of things which keep on coming, or the new labor laws related requirements come, or if the system changes to digital kind of atmosphere from, let us say, the physical share system to you get into the dematerialized kind of system, and also a lot of changes keep on taking place all the time. And the organizations have to adapt themselves to the new requirements and the new situations. do you get the responsibilities to sort of enable that, or somebody else is in charge? That is the second set of, to my mind, the legal related responsibilities which can be. And the last, to my mind, is what I would call the leadership roles, where you think proactively, beyond proactively in the sense, rather than abiding by what the current laws are or are evolving into, you start thinking that what should be the law of the country, what kind of right laws we need in these countries, and then you start studying the developments all over the world and which way the change is going, and then you try to create a sort of forward-looking a leadership role that let us sort of not only adapt, but let us evolve ourselves into something which can, and then you also take up the role and responsibility of modulating, modifying, defining, leading the national system, the courts and others to sort of think that way. That is the leadership role, to my mind. So I think between the three set of laws, the fundamental, the ecosystem, and the compliance or the regulatory system, and the three kind of responsibilities, reactive, proactive, and the leadership, I think that is where all of you, to my mind, can sort of look at what your theme of today is: rethink, redefine, and re-evolve. I think if you scan the environment around you and you find that how things are right, how these laws, the way the system is operating, is it conducive for the businesses to thrive? Is it conducive for the businesses to do well? Or can they realize their best potential in the circumstances? Can they produce the goods and services which are very much best at the most competitive prices and things like that? If you start looking at those questions, how does the legal system operate? How does, let us say, the first kind of responsibilities, if you want to think about, do we have the right kind of labor tribunals? Do we have the right kind of taxation related systems? Do we have the right kind of securities tribunal system? Do we have in the country appropriate kind of ushering into the environmental laws and their enforcement or not? And you also start looking at the way the courts, Supreme Court is interpreting, the way the government is doing. Is that, for example, let me give you a small example. Some time back, the Supreme Court came up with a direction that you can't have excise or the liquor shops within 200 meters of the roads. Now, this may seem somebody who is moved by a kind of paternalistic, pious intention that no, this will affect people's health, and therefore it should not be the case. But if you look at from the business point of view, the way the transportation system operates in the country, the way the businesses operate, you can't have a shop which is 200 or 500 meters away, tucked away somewhere which nobody can see, right? So that is something which requires to be sort of dealt with at that level. You need to do a lot of studies, find out why this is not, present that viewpoint, argue this very. Similarly, you can have in many ways. These days, for example, the environmental laws are receiving the highest kind of attention. Somebody in the SEBI tells you that you have to file this kind of return to give you that scope 1, scope 2, this kind of report you file. But can you think, and do you think that is this the best way to proceed further? What is our objective? Our objective is that the emissions both of carbon and the pollutant, those emissions should come down. Those should reduce. And the businesses don't socialize, so to say, the pollution at the cost of the society. But is that way that only if you file some returns and provide some information without any enforcement, or is that too much of information to ask? Let me give you another example. This keeps on coming up many times in our debate, that there are about 70,000 compliances relating to labor laws and the industry laws in the country. Manish Sabharwal keeps on doing a lot of work. And we in the government have this tendency of sort of prescribing a form at the drop of a hat that give this information, give that information. Now, what kind of load this leads to the businesses, we don't assess. But what I find also equally surprising is that it doesn't come back from the business that this is not the best way. Business seems to be intimidated, many times timid in arguing out with the government that no, what objective you want to achieve is not, this is not the best way to achieve. I think if we can evolve that, I remember one discussion in one of the meetings which we used to have before the budget. One guy who was in the new digital business, he said, we have 3,000 compliances to do. And we have developed an electronic system to comply with all of them. And the government is comfortable with that. This provides, whatever they do with that information is not my concern. And in my impression is that they don't use virtually any of it, but simplify it. But still I'll do it. But there is an additional requirement. The additional requirement is that I have to print out all of them and give that as also another. So why this additional requirement of printing out those and put that nonsense or whatever you may say into the government's room, which they don't even look at. So I think there is enormous amount of space in this country, or the problems, if you want to put it that way, where lots of intellectual work need to be done, and not only for and the government, the courts and others need to be sort of engaged to sort of reform that. Last thing, I'll give an example, and then I think my 15 minutes are getting over, so I'll stop. So we passed this labor laws in 2020. It's more than 4 years now. If you study very carefully, that was more or less a consolidation of the existing 29 laws into 4 codes. That was not a business process re-engineering of the labor laws. But so be it, whatever it was, it has still not been, after 4 years, been made applicable. Why? What is going on? Are you, as part of the industry handling corporate responsibilities, what is your view there? Do you think this is the best way? Or if you see the way the industry has evolved all over the world now, there are the old concerns of satanic mills or factories sort of exploiting the labor, health and all, those are all gone. Do we need those kind of laws still? What should be the ideal kind of labor codes? I think if you think about that, you will find the solutions lies. What about the digital privacy laws which are coming up? Will that actually help? Because there, the biggest aim is to sort of somehow ensure the protect the privacy of individual data, right? Or that India's data should not go out of the country. These seems to be the two driving forces behind those laws. But is in this environment, when you have the AI and other things kind of sort of taking the data from anywhere to anywhere, or how does it affect the businesses and all? I think there are a large number of issues. I can go on where the legal community, legal fraternity if it takes more interest, can come up with much better solutions. You can definitely help the country in evolving, rethinking, and redefining this thing. Thank you very much for the time. Thanks a lot.
Thank you so much for that insightful address, Shri Garg. To present the memento, I would like to call upon Lubnisha Shaha, founder, GCAI, Head of Legal and Compliance, South Asia, Airbus. Thank you so much. We will now move on to our next keynote address by Sri Dhanendra Kumar. As the first chairperson of the Competition Commission of India, CCI, Sri Dhanendra Kumar was instrumental in laying the foundation for the institution, establishing its systems and ensuring its effective functioning. He also chaired the committee responsible for drafting India's national competition policy and amending the Competition Act. His efforts collectively have put India on the global map, showcasing its commitment to fostering a competitive and fair market environment. Before his tenure at the CCI, Shri Kumar served as the Executive Director for India at the World Bank and has held several high-profile positions in both the Government of India and the State Government of Haryana. Shri Dhanendra Kumar will share his thoughts on the impact of evolving laws and regulations on the ecosystem. Welcome, sir.
Good afternoon, ladies and gentlemen. It is my honor and privilege to speak to you in this conference today on a very eminent and very concurrent subject on rethink, redefine, re-evolve legal profession in India. My greetings to you, Sanjeev Khemawat ji, Manjuri Chaudhary ji, and all the friends. I see half of the friends sitting in the audience. I'll speak to you within the time allocated to me, about 15 minutes, on the evolving role of the general counsels of the corporates, what it is, and what, in my view, it should be. Sometimes it reminds me of somebody who is asked to play as a boxer with his hands tied at his back and face all the blows and try to give the blows when his hands are tied. Now, the problem is that we are living in a dynamic world. The laws which exist are static, and in the common law traditions, it is evolving, but we are still stuck in where we had. So the laws are evolving, the expectations in the corporates are changing, business strategies, governance, compliance, new laws are emerging on ESG, on data, CSR, and so on. Every day there are new laws which are coming up. Also, the fact that the general counsels are expected to guide the corporates, guide the managements, guide the board of directors, and they expect that they would help the companies to stay on the right side of laws in compliance and also in growth. But they are not allowed to practice, they are not allowed to appear before the regulators, and they are not allowed on many other things which the counsels, which the advocates are allowed in terms of the protection and so on, the opinions which they give. The nature of local and global laws are changing with the forthcoming entry of foreign law firms in India, also the artificial intelligence, the digital laws, the gaming laws, the data privacy, and so on. So the entire ecosystem is changing and changing very rapidly. In this situation, how do you attract the bright youngsters when you don't allow them the right tools? So we need to stay current with the expectations of the society, your clients, and also the regulators where you are serving. I was listening to the very bright minds who were speaking just now, artificial intelligence, the use of the various tools which are available. Let me tell you, and I've been chairman of CCI, the regulators also use them. So if you don't use them, then you would be staying behind. And there is a competition now within the tools also. Now with you have the deep, Seek, and also now we have the Alibaba also coming up with a new open AI and so on and so forth. So hopefully we would have a lot of choices. You can choose your tools, but in the expectation that you produce the best, it is necessary for you to at least know what exists in the market. The general counsels, in my view, they form the backbone of the corporates and to that extent the economy as a whole. They are the trusted advisors of the board of directors, the CEOs, and the heads of divisions. Little while ago, my colleague in the World Bank, just later on, we had Subhash speaking. I'm reminded of a particular anecdote in World Bank when I was there with India's executive director. I wouldn't like to name anybody, but at that time, the head of HR, he was facing a problem, and the CEO, the president of the World Bank, was putting him under a lot of pressure to do something which was not quite legal. He wanted to promote somebody out of turn, his live-in girlfriend, if I can be more precise. But he didn't want it, she didn't deserve it, and he didn't know what to do it. So he asked his friend, who was the general counsel of the World Bank, and he took his advice, what should I do? And he gave him a very interesting advice. He said, you, every day when he calls you and asks you to do this thing, you send a mail to yourself. And at some point of time, when there is a investigation or something, there is bound to be, then this mail would come to you in a big stead. And this is what he did. And when we, in the board of directors, looked at the whole thing, we got all the evidence, and we were about to remove the president at that time when he resigned on his own. My point is that the general counsels can give advice to the divisional heads and also to, in very critical situations, with their experience on law and what would probably come to them as the best solution. And this is the reason why in several situations we have seen in Harvard Law School, for example, Professor David Wilkinson, he wrote for the Indian context that the general counsel's role is becoming more important as India's economy is becoming globally integrated, as is legal awareness of the new generation of entrepreneurs. And also in the same Harvard Law School, another professor, Benjamin Heinemann, he writes in Inside Counsel Revolution that there has been an inside counsel revolution of increasing scope and power. General counsel and corporate law departments in top global companies they have become more sophisticated, capable, influential, transforming both business and law, and also concerned with ethics, risk, governance, and responsibility, and so on. It's a long note which he wrote on the evolving role of General Counsel in corporates. The role of General Counsel is pivotal in corporate governance. His traditional role to render legal advice to the management, draft and vet legal documents, contracts, arrange compliances, etc. It is there, but the new roles which are coming up now, he is supposed to be absolutely up to date in those also, and therefore he is now virtually the friend, philosopher, and guide of the board of directors and also of the company as a whole. Over the past few years, there have been very rapid changes in the legal architecture and compliance needs, and there are situations when the image and reputation of the entire company, entire institution depends on what is done and what is not done, and therefore it is important for the General Counsel to be concerned with the reputational and fiduciary duties of the board of directors and the company. And therefore, the role of General Counsels, in my view today, is probably the most important among the various C-suite heads. And it is the reason that in many of the very big corporates, for example, in the Microsoft, Satya Nadella announced the elevation of Brad Smith from GC to the president and CLO. And in Google, Ken Walker was elevated from GC to senior vice president of global affairs and CLO for much expanded responsibility, and many other instances exist of this kind. In the practical example, I can give you a few instances when I myself saw, when I was chairman of the Competition Commission of India, that at that time, when I heard the councils, the external councils, and sometimes there was too much cloud in the main issue, I would invite the general counsel who was standing beside and ask him some pointed questions, and the whole thing was clear because he knows exactly where the problem is, what the shoe pinches, where the shoe pinches, and what are the possible solutions. And therefore, I see absolutely no reason why the general counsel should not be allowed under any regulation not to appear before the regulator. And in my view, and this is true also in many other countries, many other jurisdictions where similar common law exists. Some large corporations have very big internal legal divisions. I mean, just to name a few, Reliance, for example, they have very large internal legal division, and similarly, many others globally, they do it. And many Supreme Court judges, Mr. Honorable Justice Gogoi, for example, he has been speaking and supporting this demand, and many others. I'm sure you will have many more judges coming this evening also, and maybe some of them would also like to say the same thing. In US, UK, Singapore, and Hong Kong, the role of GC is much expanded and defined to include many new things. The reality today is that modern GCs are shaping corporate governance, leading ESG compliance, managing complex litigation, driving cross-border trade, spearheading legal tech divisions. In UK's Solicitor Regulatory Authority and the American Bar Association, they also fully integrate corporate counsel, and the Advocates Act and Bar Council of India, where regulations deny this thing to GCs, I think there is need to amend the Advocates Act to recognize GC as advocates, create a dedicated Bar Council framework for in-house counsel, grant privilege protection to GC legal opinions, introducing tailored CPD requirements, regulations governing cross-border trade and investment in the fast-changing digital era, compliance with the IPR and innovation regulations. As India prepares for the $10 trillion economy in the coming era, and we had the president's address today, and she came out
with a lot of initiatives which have been taken and which are being taken. And we had the chief economic advisors, the Economic Survey of India, and going through it. And the government is working towards very expanded economy for the country when India would become a developed nation. I think the role of general councils in India is going to be extremely important. And therefore, in my view, it is important that they need to be equipped with all the wherewithal which is necessary. In the end, I'm just reminded of a small anecdote which I read somewhere. That was, when we were students. So once Akbar asked Birbal, कि भाई ढूंढ के लाओ ऐसा नर पीर बावर्ची भिश्ती चर जो सारे काम कर दे. पीर बावर्ची भिश्ती चर सारे काम कर दे. And he said, sir, you only need general counsel for this. So thank you very much for your attention. And I look forward to some very productive recommendations after your deliberations. Thank you very much for giving me this opportunity. Oh, thank you very much. So,
Thank you, Ms. Lubnisha, for sharing the memento. Thank you so much, sir. We shall now move towards the next session of today's event, the Futuristic GC. What will it take and what truly matters? The eminent panelists for this session are Dr. Rajiv Mani, Secretary, Legislative Department, Ministry of Law and Justice and Law Secretary, Department of Legal Affairs, Ministry of Law and Justice. Sanjay Shori, Director General of Corporate Affairs, Ministry of Corporate Affairs, Government of India. Mahavir Sanghvi, Joint Secretary, Ministry of External Affairs, Government of India. Manpreet Singh Ahuja, Chief Digital Officer, PwC India, Rajatvi Partner, Deloitte Touch Tatmatsu India LLP. Please join us on stage. This session will be moderated by GCAI member Purnima Sampath, Senior Vice President and Chief Legal Officer, Tata Digital. Let's start. I will come there then.
This event of the General Councils Association of India couldn't be timed better for a bunch of reasons. One, I'm sitting with a very distinguished panel, so please give them an applause before we begin. When I say the timing is brilliant, I think it's because in the last 2 weeks, a bunch of things have happened. First of all, there's been DeepSeek. I mean, it's just it's just blown everybody off, right? Just in terms of price, in terms of invention, innovation. China's done it all over again. So we will spend some time today talking about AI and what it means for the legal industry and for India. Geopolitically, in the last 2 weeks, again, there've been a bunch of things, right? I mean, where do you have a president that calls up Denmark and says, hey, listen, I want to buy Greenland? Where would you have a president that, calls up somebody in Canada and says, hey, listen, you should ideally be the 51st state of the United States? Or someone calls up Egypt and Jordan and tells them, hey, listen, you want to clean up Gaza? Brilliant idea. Go for it and take the refugees. So I think geopolitically, things are really going to change, and that is going to impact our business and how we function. Again, in the last 2 weeks, India celebrated the 75th year of us adopting the Constitution. So I'm going to spend some time taking off on fundamental rights, right to privacy, what that means for data, what that means in the context of identity theft. We'll spend a few minutes on that. Just in the last, not just the last 2 weeks, but in the year preceding today, if I were to think of the developments in industry, for me, the fact that India is going to manufacture semiconductor fabs is we've just hit it out of the park. We haven't done it yet. It's on the road. We've started, but it's truly something. Electric vehicles, we've got Manjari here from Maruti. Electric vehicles, there's obviously Tata Motors as well. It's a brilliant jump for this country. So welcome all of you. Thank you for joining us on behalf of the General Counsels Association. I don't think it's a coincidence that we're meeting here today. I'm privileged to work with, when there's Manjari, Tejal, there's Raghu, Akhil, they have a lot of foresight, a lot of commitment to legal issues, and a hell of a lot of foresight. So an applause for them as well. And, I called up everybody on this panel, and everybody said, I want to talk about AI. I was delighted. I think it is quite the topic of the hour. So it will be more of a discussion. First question for you, Mahavir. How do you envisage India's progress with AI? And taking off from there, what would it mean for councils?
Thank you, Purnima. Where is Sanjeev? I think I should thank him for inviting me here. As a dear friend, we go back almost 40 years, and he's been a very close friend. I have seen this organization growing from the scratch. I recall that the launch was done at a golf course, and I think it was ITC in Manesar. And from there on, I'm very happy to see today that we are at IIC, and that shows the kind of progress this organization has made over the years. So I'm very happy to be here. I'm here in my personal capacity, of course. Sanjeev, whenever he invites me, I can't resist, and therefore I said, okay, I'll come over for some time, though it's a working day and in the middle of the office hours. But again, I said, of course, I'll come and give my views, whatever I have. Oh, Sanjeev is here now. So, okay. Between them. Okay. So Sanjeev, I was just talking about how this organization has actually grown from golf course to IIC, and that's the kind of progress which you have made, and that shows that where you are right now and where you will be in coming years. So thanks to you for inviting me here. Now coming to the subject of artificial intelligence, let me just give a background of what I do in the Ministry of External Affairs. I think many of you may not be knowing about this, so I thought it would be relevant to talk about that too. So, the technology is really changing everything nowadays. We are at an inflection point where in the coming years, I think everything would change. And the government has realized this at various levels. Of course, there are line ministries who deals with a lot of technology issues. But in the Ministry of External Affairs also, there was a thought that we need to strengthen our tech diplomacy. And the thought actually got translated into action in 2020 when the COVID was at its peak. Then we decided to open up a division called New Emerging and Strategic Technology Division. And from last 1.5 years, I am heading that division in the Ministry of External Affairs. And we deal into a whole host of technological issues, including artificial intelligence, quantum technology, semiconductors, space, some sort of defense technologies, and biotechnology, synthetic biology. There are many things which we are dealing with. And the aim is to strengthen our ecosystem by having collaboration and cooperation with different countries on this aspect. And we have entered into some of the very important partnerships with some of the countries, particularly with the United States. We have ISET, Initiative on Critical and Emerging Technology. With UK, we have recently entered into a technology security partnership. With EU, we have a Trade and Technology Council that's at the ministers' level. The other two mechanisms are, of course, headed by the NSA. And then there are different verticals, there are discussions on different levels under those frameworks. So we are working very closely with all of these, and we're trying to see that whatever is available outside, we get here in India. And as we go forward, and as the Prime Ministers often say, as we look towards 2047, we'll be a developed country. I think technology is going to play a very important role in that. And artificial intelligence particularly is going to play a very, very important role in that, in terms of leapfrogging our development in the times to come, be it in the healthcare, be it in agriculture, or any sector. Artificial intelligence is going to change almost every sector of the economy, and including legal services. And we are seeing it already, in fact. And of course, as a General Counsel, all of you must be aware. Some of you have already started using artificial intelligence in the legal services, whether it's contract drafting or examining the contracts or so on and so forth. So I think artificial intelligence is everywhere now. We are using it even without knowing it actually nowadays. And as you have seen, the technology is changing so fast that is upsetting a lot of things day by day. Every week there is a new development, and we have to adopt and adapt to it, basically, in various ways, be it at an individual level or at a society or a government level. So these are the things which are happening right now. I see a very important role for artificial intelligence, as I said, going forward in the country. There is an estimate that by 2030, artificial intelligence is going to contribute almost $15 trillion to the global economy. And we are going to be one of the major beneficiary of this. We are also expecting to add a significant number to our economy in the next 5 years using artificial intelligence. Now, there are, at the same time, artificial intelligence provide a lot of opportunities, and it would leapfrog the development. But there are concerns also, and all of you are aware of those concerns. That how do we make artificial intelligence safe, secure, trustworthy, and responsible? I think these are the 4 keywords which are, I think, very important when we talk about artificial intelligence in terms of taking it forward. And these are also very closely concerned with the way artificial intelligence is going to be regulated in the country, even whenever we think about it. As of now, there are no specific regulations. There are various provisions under different regulations and acts where different aspects of consequences can be taken care of if it is leading to some sort of a harm. I think there are various ways it can be dealt with, but there is no specific legislation as of now. But maybe in the future, as we go forward on this path, something may happen. So I think there are a lot of things which needs to be done. We should go forward on artificial intelligence, taking all these 4 keywords which I mentioned just now, and that is very important for general counsels also to actually take into consideration in their work as they go forward. Thank you.
Dr. Mani, the gap that Mahavir mentioned, that there is a lot of progress on the AI front and legislations are yet to keep pace. Could you share your thoughts on the legislative lens for AI, data, digital platforms, all the new emerging areas?
Thank you. As we all know that technology has invaded all walks of life. And of course, it has benefited immensely in every sector of our lives, whether it is the economy, trade, commerce. In fact, I was reading an article sometime last year wherein in Brazil, the chat GPT, a municipal councillor in a small city in Brazil had drafted a law by using chat GPT, and then that law was introduced in the council and it was passed unanimously. Subsequently, I think his conscience pricked him and he disclosed that he had not actually drafted the law, but he had taken the use of chat GPT for say. But anyway, the law was passed. So the way artificial intelligence is, going to grow in our country, and of course, it's very useful in many of the sectors. In fact, as far as the legal sector itself is concerned, the Supreme Court is using artificial intelligence to translate its judgments into various languages. Most of the 8th scheduled languages, the judgments are now being translated with the use of artificial technology, the software which has been developed by the Ministry of Electronics and Information Technology and NIC. The use of AI in agriculture, in economy, in weather forecasting, in legal sector is immense. Now, as you rightly mentioned that it is still not within the purview of the legislature. I mean, there are no legislations which govern the AI. It's a field growing at an immense pace within a very short time. And what we imagined as AI in movies about a decade back are a reality now. And maybe in the next 5 years, as we I've read in various reports, it is going to impact us in a significant manner. Already there is a talk in the government about how the new emerging technologies to be, discussed, how it is to be regulated, whether by rules or by any principal legislation. And the ground now is fertile for such a discussion. And we had some rounds of discussion, initial with the experts also. I think by this year or maybe in early next year, there should be something which, which can be moved for public consultation as a part of the lawmaking exercise as to how we do it, because already we are in the process of, I think new Information Technology Act is also in the offing. When it comes, it's a matter of time. The DPDP Act, the rules already are, placed for public consultation, and once they are published, notified, I think that will also, to some extent, lend some, sort of a semblance of the use of AI in various mediums, wherein some intermediaries involved. So I think the ground is certainly ripe for a discussion on these various uses of AI. Of course, we also know the flip side of the AI and the deep fakes and the way it can harm the reputation of any individual. So definitely there is a need for a legislative intervention. In what manner and to what extent, that would depend greatly on the feedbacks and the discussions which happen in platforms like yours and they would certainly, give some good, way forward for the policy makers and the thinkers to, suggest legislative policy in this regard. This is what I feel for the present. Thank you.
Narrowing down from what is good for India to what is useful for corporates. And over to you, Rajat and Manpreet. Both deal extensively with technology for councils, with forensics, fraud investigation, cyber security. Over to you.
Yeah, if I can choose to be a little candid in this room, Mahavirji said $15 trillion by 2030 is the economic impact of AI. And some of the biggest, largest corporates are sitting here. I want to get a pulse from the room as to, do you really feel, do you smell enough throughput on AI shaping the product, shaping how we are reaching the customer, shaping how our channels getting disrupted, shaping how our supply chain is changing, and last but not the least, shaping how the legal function is moving? I don't think we as a country are moving fast enough. And I think the corporates, the Indian corporates, have to kind of take a leap of faith and move faster than where they are, because it is a $15 trillion economy. And India has enough macros for it to be able to create a comparative advantage for itself. 2025 is supposed to be the year of AI agents. And I can again go back and say, if I were to ask for a raise of hands saying, how many of you smelled AI agents doing, forget about autonomous work, going beyond just searching an LLM and getting assistance to augmenting it for an outcome? Not much is happening. So, that's just one headline point, because, as a CDO at PwC, that's my day job. I go out, meet companies, talk about AI, and bringing home the point relevant to the room here. I think just in the world of general counsels itself, you're far more than the gatekeepers for the legal fraternity, right? For the legal risk. To be a business advisor and to really be able to make a competitive advantage, there's so much that's changing all around. And you possibly hold the nerve center of all contracts that are happening, which holds technology, which holds IP, which holds commerciality, and that world is changing. So if there's an AI agent that's constantly tracking that change and connecting the dot back to the GC's office saying, here is a big change that's happening that could have an impact with the underlying commercial construct or a contract that you signed 6 months back, there's value back to business that you could create. It's all possible today, but I think for that, some of those fundamental pillars that kind of roll up to the legal fraternity need to kind of get digitized and bring in AI. So the way contracts get managed needs to go through digitization. The way the regulation gets tracked and the horizon scans get done needs to get digitized. There's this massive effort that goes into legal research that needs to go through a layer of AI. Proactive risk management needs to go through a layer of AI. So there's just a lot of many use cases that the legal fraternity can use to be able to not only make their day jobs a lot more efficient, but actually contribute much beyond the legal and the risk agenda back to the broader organization.
Thanks for having me here. In fact, I was thinking, surrounded with so many lawyers, I should be careful in what I say. But no, I think in terms, so my day job is, I do investigations and a lot of forensic work. So in that capacity, I do deal with a lot of GCs, right? I think, the point where, again, AI is a very sort of, large word. And definitely, I think I agree with Manpreet in terms of, the corporates, especially the GC function, there is lots to be done. But in my experience, I think there are two things which sort of, are happening. One is in terms of, I see a lot of contract management systems, which are sort of, now being used. And this could be in the different stages of evolutions. Some of the companies already sort of, are talking about putting an AI layer on top of, an existing contract management system. And, some of the others are talking about, okay, which one will be perhaps better suited for a requirement. So that's a trend, at least, that I'm seeing. The other side is that, and this is, if we draw a contrast to the West, discovery, on the discovery side, the minute you get into any matter which needs to be sort of, looked at from a response perspective, there are several sort of, technology enabled solutions that I see the GCs are sort of, looking at and utilizing. Having said that, they're also, again, in terms of the functionality, in terms of the, the automation which is coming through, is something that, we are going and we're seeing in the current market scenario. But again, I mean, technology is in everything that we are doing. And to my mind, GCs are very pivotal, even if it comes to reporting. And I think, there is something on the ESG that you sort of put out. Look at an automotive sector today, right? In the automotive sector, the lot of data is compiled by the OEMs. And, that is being used for sustainability reporting. Now, the whole, technology workflow around that, the verification of that data, I think GC office becomes very sort of, pivotal to looking at that, because that is being sort of submitted as part of the reportings. And we've seen, various cases in the public domain, where it has sort of come back to affect the brand and reputation.
So the basis for the first step in AI is really data collation, and it's the quality of raw data that goes in. And on data, we've just got a new set of rules. There's new legislation. The penalties are very steep. India has gone the EU way, for better or for worse. So Rajat, what do you see from a corporate governance angle? I know you deal a lot with investigation, but before something really becomes an issue, do you find strategies changing in companies that you work with as they deal with data and data governance?
Sure. No, absolutely important point. And I think let's draw towards the startups of the country in that sense. If I'm not mistaken, there were about 74 main board IPOs last year. And I was reading today, I think there's about 80,000 crore worth of unlocking of the time period that's going to come, shortly in front of us, as well as, many more SME IPOs, right? So we are seeing, there is a lot of push around the startups ecosystem, as well as, the IPO stage eventually sort of, coming through. And we are seeing that from a corporate governance perspective, and I think this has been discussed in many forums, that instead of focusing only on business, now there is a very, very sort of, acute need at the board level to look at a broader corporate governance environment, in all these companies. Because by the time, and I think without naming companies here, there is lots which is sort of, which are the matters that we keep sort of, popping up. What is, I think, important is, and the board and the audit committee and the independent directors are asking the question that, guys, what are we doing about, enterprise risk management? What are some of those, key controls and monitoring mechanisms that are sort of, should be working in a company environment? And, before it's too late. Until something sort of, pops up, I mean, that's the point when we go back and see, okay, what should have been the control? So, lot more focus in terms of prevention and detection. And that's where I think, again, GCs will, and are playing a very sort of, pivotal role. I mean, as basic as, the policies around code of conduct, whistleblower mechanisms, and ranging, from there to lot more on the corporate governance side is, I think, going to be the need of the hour. Not only this, I think from an investment scenario, and when I look at an M&A perspective, in terms of valuations, in terms of due diligence, when we are doing due diligences, we are actually specifically asked for, bribery and corruption diligence in some of the sectors. We've seen infra as a big sector. We've seen renewable as a large sector. So as part of the diligence as well, so the investor communities are also sort of, saying that, look, we need to see more. We need to see how the controls sort of, are embedded in the processes and the overall mindset of the promoters of these companies. I think we can go on this topic given the limited
Thanks.
time we have.
So, Dr. Mani, when it comes to data, AI, digital platforms, maybe even digital competition rules, um, do you favor, for instance, principle-based legislation as opposed to rule-based? And I'll tell you what I think the distinction is. With principle-based, you assume people will largely follow the letter of the law and the spirit of the law. And I think with a lot of SEBI regulations, I find is rule-based because they actually want to spell it out what the do's and don'ts are.
Well, law is an organic document, it's a living document. So initially, I think when we, attempt to regulate any new technology through legislation, we have to be flexible enough to accommodate, the changes which may be happening in the way the technology develops and the impact it has on the society, on the state, on the citizens. And therefore, I think there has to be a unanimity amongst the stakeholders about the various aspects which need to be looked into while, we think of having a legislation to regulate a technology which has such an immense potential to affect our lives. The data protection, digital data protection, personal data protection law, which has, is one such, step in this direction. And where if you have a reading of the said law, you will find that the law actually lays down a broad concept. And most of the law which, will emerge, we will find in the rules and regulations and not in the main principal legislations. Similarly, for any new aspect which is to be regulated, I think there has to be some broad concepts which need to be laid down in the law, giving enough flexibility, to the government or to the executive to regulate the various purposes, for which the law has been enacted. Some of the purposes may be explicitly stated in the legislation, which need immediate making of the subordinate legislations, while many of them may not be there. But if we make the law broad-based, so as to the language, is flexible enough, inclusive, so that the emerging challenges which the law may face during its journey from its inception, after its passing by the parliament and its operation. So that flexibility is required at least in the field of AI. And it has, cross-cutting impact on various other legislations also, whether it is economic, whether it is cyber fraud, or it is cyberbullying, or, stalking, cyber stalking. So many aspects, the artificial intelligence has a, big role in that. But similarly, to, realize its potential and utilize its potential for good governance, it needs to be promoted, encouraged, along with adequate provisions for, protection of the privacy, protection of the data which it generates. So in my view, I think the initial legislations, whenever they, are enacted, should be broad-based on the lines of the DPDP Act, giving enough flexibility to the executive, to frame rules to deal with various situations that may arise in due course.
Mahavir, in your experience with the NEST, the New Emerging Strategic Technologies Division, can you perhaps share a couple of initiatives that may give all of us a sense of how this branch of government actually deals with other countries on AI, on technology?
I think I've already. Hello. I think I've already mentioned that what we do, but If you're specifically talking about AI, then I would say that a lot of developments are happening all over the world. You see every day something coming out. You just saw, a few days back, which has set in motion, the thinking whether the kind of AI which was earlier envisaged would continue or it will have a different kind of dimensions altogether, whether we really need large language models, investing billions of dollars into it, or a alternative which has come out recently can actually take care of the things or requirements of the country concerned in terms of whatever applications you're looking at it. Internationally, I would say that if you look at the governance aspects of it, various discussions are happening at different levels. There is a global partnership on artificial intelligence, which was set up 3-4 years ago. We are a founding member of that. We were actually a chair of that during the last year in 2024. We had a ministerial meeting here, ministerial summit here in New Delhi. That summit had laid down in the Delhi Declaration, that what should be the contours of AI in terms of when we are looking at its governance or its development in future. What are the things which we need to actually consider in terms of regulating it, or in terms of developing artificial intelligence and using it. Similarly, at the UN also there is a discussion which is going on for artificial intelligence. The UN has come out with something called Global Digital Compact, which include both on the digital side and also on artificial intelligence, certain guidelines that what countries need to be doing, and also what are the things which UN is planning to do. So there's a scientific panel on artificial intelligence which the UN is planning to set up. Similarly, they are also planning to have a kind of a global conference on artificial intelligence, global dialogue on artificial intelligence on the sidelines of the UNGA. So many things are happening. We are going to have again, a very big meeting, a summit of heads of states and stakeholders on 9th and 10th, from 9th to 11th of February in Paris. The Prime Minister is also going, and we would be co-chairing that meeting. So we are on top of all the international initiatives which are being taken in terms of artificial intelligence. We have one of the highest adoption rate in terms of artificial intelligence applications in concern. We are one of the countries which have been involved in discussions at every level. Most of the summits which are happening all over the world, we have been a part of that. We've been contributing extensively to it. We have now an artificial intelligence mission also, India AI mission, where the government has set aside almost more than 10,000 crores of rupee to develop artificial intelligence ecosystem in the country. That is including providing compute facility also to the researchers or those who want to develop applications. So there are many things which the government is doing. We are involved in many things in terms of our participation, and we are also trying to see that whatever is happening around the world, we have all the necessary participation and information about all the things, and we become a part of all the initiatives on this issue, because this is going to be very, very important in future. We are on top of everything. Perhaps you may not be aware of it, but government is looking all these developments very, very closely. That's what I can say at this point in time. Thanks.
Thank you, Dr. Mani and Mahavir, for walking us through the changes at a macro level, geopolitical level. It's great to know what the different platforms that India as a country is working on. Thank you, Rajat and Manpreet, for sharing your thoughts at a more micro level and what it means for Indian corporates, what it means for councils, general councils. Thank you so much.
Thank you so much, everyone, for sharing your experiences with us. And I would now request that please come on stage Dr. Sanjeev Kemawat Founder, GCAI, Managing Director, and Group General Counsel, SR Group, to give away the mementos. I would also request the panelists to please stay for a group photo. Thank you so much, everyone. We will now break for 10 minutes for a short tea and coffee session, which is served outside. You're requested to please bring in your beverages inside as we shall begin shortly again. Thank you. that we can start the rest of the event. We hope that you all have taken your refreshments and beverages. Like I mentioned, you can always take your refreshments and please come back to your table. Thank you so much. As I see, most of us have settled down with their refreshments. We'll now continue today's event. So resuming today's event, this session is a special one with a theme that we feel is intriguing and solution-based at the same time. Welcome to the third session of the day, Enabling and Skilling. At the panel, we shall have Professor Dr. G.S. Bajpai, Vice Chancellor, NLU, Delhi, Professor Dr. Shubhashish Gangopadhyay, Founding Dean, ISPP, Professor Dr. Ashish Bharadwaj, Founding Dean, BITS Law School, Professor Dr. Avinash Dadhij, Founding Director, School of Law at Dhirubhai Ambani University, Mr. Naveen Tuli, Managing Partner, EMEA and APAC In-House Practice Group at Major Lindsay and Africa. And to moderate this session, we have GCAI member Shelley Kohli, General Counsel, United Breweries. We have with us on the panel Dr. Rishram Garg as well. Thank you so much for joining us, sir.
Yeah, so I am really feeling very privileged to be amongst, some of the ace academicians of the country and also a legal practitioner, Naveen. And we are going to talk about legal education. So just to set the context, legal education in India has actually gone through a significant amount of evolution and transformation. From being a marginalized discipline, it is now an extremely prestigious and structured domain. And soon after independence, there was consensus that legal education has to be imparted through specialized institutions, just like the study of medicine or engineering for that matter. And this led to the establishment of the NLUs, and the first model was introduced in 1987 with an integrated 5-year program. The establishment of the NLU model actually coincided with economic liberalization in India, which saw a lot of influx of foreign investment coming into the country and a rapid growth of industry. And this created unprecedented amount of opportunity for law firms in India to give a lot of specialized legal advice in new domains, including arbitration, intellectual property, information technology, mergers and acquisitions, etc. And this era actually laid the foundation for modern, multifaceted legal ecosystem. In early 2000s, we saw a lot of new regulatory frameworks evolving and a lot of sector-specific regulations come in. And what this did was a creation of in-house legal departments where the lawyers were tasked not just with interpreting the law, complicated laws, but also making sure that the companies stay compliant. Soon, in-house legal teams transitioned from being operational to strategic advisors and the chief legal officer or the GC becoming a key member of the executive team. Now, modern in-house legal teams, if I talk about them, they have become an integral part of business strategy. And they provide in-house legal departments also, now this is subject to debate a bit, but they do provide a better work-life balance. Also, companies are investing heavily in their legal departments in terms of their learning and development.
despite these some very tangible benefits, we see a lot of law students actually gravitate towards law firms. And that brings me to you, Dr. Risham, with my first question as to what can legal in-house teams do differently to ensure that we attract top talent? And also as law schools, what could you potentially do in terms of level the playing field between law firms and in-house roles? Dr. Risham.
Thank you, Shelly, for that wonderful question. And thank you, GCAI, for inviting me to this panel, and congratulations for a wonderful event. The time when we started our, learning and studying the law and joining the profession, it is, famously everybody says was by chance, not by choice. Most of us in my generation. But there's a difference. Today's generation, they are by choice. And they participate in a very tough entrance exam. There are selection of the best. There is, the entrance exam is tough. They prepare very well. And the students of today, they are career oriented. They look towards the opportunities. They are looking towards the opportunities of growth. They're looking towards the opportunities that what a particular field of profession, vocation, or employment has in future for them. So the general counsel's job is good for a company. It is good. It is wonderful. But are they, able to be satisfied for that, that zest? I am a lawyer. I want to argue. I want to speak. So that inherent, ambition, or I won't say craze, but there is an aspiration that I want to speak, I want to argue in the courts. So that is an inherent element which they are looking. So they are also looking to enhance their career prospects and what the job profile has in store for them. It's not just seniority like the corporate, but I think we need to think about how the corporate setup, it's a company setup, but if you're inviting lawyers, how they can be incentivized that, okay, it's not just you're going up the ladders in the corporate job, but even in your legal acumen, there is that job satisfaction element. So probably these are some initial thoughts which I could portray.
Sure. Thank you, Dr. Risham. Now, we've spoken a lot about AI today, but we as a panel have to actually examine that subject from the lens of legal education. Now, Gen AI, especially while it enhances efficiency and provides valuable tool for research, it actually raises a significant concern around originality and authenticity when it comes to academic output, which is of paramount importance to any law school. Law students today, when equipped with Gen AI, can actually produce legal research papers with minimal effort, which challenges the traditional method of evaluation, which emphasizes originality, critical thinking, and analytical depth. And that brings me to Dr. Ashish. Dr. Ashish, considering the challenge that I've just laid down, how do you think law schools can rethink their evaluation method to uphold academic integrity and ensure originality? And should the law schools today include practical skills such as oratory, advocacy, and negotiation by incorporating activities like moot courts, mock negotiations, and client counseling as core components of assessment? Dr. Ashish?
Yes. No. Thanks very much for inviting me. I'm Ashish. Thanks very much, Akhil, for reaching out. As soon as he said that there's a panel, there's a session, my spontaneous reaction was yes, happy to do it. I didn't read the document carefully. And early in the morning today, I realized that it's a gathering of general counsels. So I could not gather the courage to just speak. So I have some notes and I'll be reading from there. I will not be talking about law particularly. I don't want to make that mistake with this crowd. But coming back to your question, Shelly, There is going to be a lot that you'll hear. You might have heard already about AI. Some of you might be using it. And it will continuously improve. That's axiomatic. That's the nature of the beast. There are some concerns which all of us have read about in the newspapers, perhaps experienced ourselves, but all of those things technologically are addressable, so I won't even go there. What I want to really flag here is, and I hope I can answer the question indirectly, is there is just too much focus on the advantages and the magic that this technology can do. And there is a little bit more to it that we must think about. And I'm saying this with a lot of responsibility because my area of work happens to be technology, law, and policy. So I'm not against the idea of technological innovation, be it in the classroom, be it in terms of pedagogical techniques, be it to enable the learner or the instructor, or in a law firm, it doesn't matter, or in a court, it's all welcome. But I'm going to share some of my own experiences, what some of us have observed in the classroom, what we are witnessing. That's not as rosy as the picture which is being painted around AI. So the basic tenets of higher education, the idea of trust and ethics and the idea of integrity when you are learning, are you learning for the sake of it? Is it the end goal or is it a means to a bigger end? I think all of that is slightly getting compromised now. And I'll tell you how. I'm guessing that all of you are recruiting quite regularly and you're looking for very specific skill sets sometimes. And we are very keen to know that. That's this academic practice supply chain runs smoothly. But I noticed that in almost all the JDs across industries and countries, the requirement of ability to work in teams, that one needs to be resilient, one needs to have integrity, that's always mentioned. No one knows how to answer that question. I am guessing, Naveen, that HR professionals and ACE recruiters have not cracked the code how to really measure it objectively. What I can tell you, that some of the students who are going through this process, starting from high school to undergraduation phase to graduate studies and then joining the industry or higher studies, they are not demonstrating the qualities and skills and attributes that we want them to bring. I don't know how many of you will agree, but we are already seeing that when they enter university, which means something is not right in the high school level. When I speak with principals, they say something is not right at the middle school level. When I speak with all of you as practitioners, they say it is because of you, because you're not preparing them for the real world. So where do the fault lines lie? Today I want to blame it on AI. So let's keep it simple. And let me start the blame game by asking the participants a question. It's a simple show of hands. I'll take a pause because Dr. Bhasin is here. Hello, sir. Yeah. So I'll take a quick show of hands kind of a poll. How many of you know which word Oxford University picked in 2024 as word of the year? I see one hand. I see two hands. Come on. It's Oxford. It's word of the year. Happens once in 1 year. 3 hands, 3.5, I guess. Uncertain. Okay. So definitely not a lot of people know. That word is brain rot. That doesn't count. So brain rot is the word of the year 2024 because of a very perceptible, evident, proven adverse impact on cognitive abilities. I've not started to blame AI yet, but there is some problem with over-digitization and trying to get away from what some people would consider as old school or traditional learning method. But I can tell you, and we boast of the quality of our institutions, all of us. We admit great students, we give them outstanding teaching, learning skills, but across the board, ability to read, write in a focused manner and to critique, that is compromised. not only with the students who are wanting to enter a university to learn and grow, but also, I'm afraid to say, people who are joining the industry wanting to learn and grow. It's across the board, it's systemic in nature, and it might be reflected in some of the young, talented, enthusiastic law graduates that you are hiring. So where does the problem lie? And I know at least one NLU student who's sitting there. So don't get me wrong. Yeah, right there. So don't get me wrong. Youngsters are not to be blamed for this. They are not lazy. They are not anti-AI or technology. They are full of energy, enthusiasm. It is simply a response to a cultural messaging that books are slightly less relevant and technology is the savior and we should go there instinctively. That's what's happening. I mean, it's like wet cement. Children are like that. Learners are like that. Wet cement. Whatever falls will make an impression. You know that as parents. But this technology, as far as law schools are concerned, at this point, I would dare to say that it is unfortunately coming across as high-tech plagiarism at this point. And I said, I made a disclaimer at the beginning, it will improve, it has to improve, and we'll see that soon. At this point, it's not helping at all. It's having a very, very adverse impact. And people are trying, they're trying in their own ways. There is immense potential. I'm sure we did a pre-call before this session. My colleague here is going to talk about some really beautiful application areas of this technology also. But unfortunately, we are doing to AI what we all did to social media 25 years ago. When Orkut, Facebook, all of that was new, what did we do? We got absolutely amazed by it. We promoted it. We practiced it. We invested in it. We scaled it. Then we got scared of it. Now we are tired of it. And now we want to regulate it. And some countries have started to ban it for a certain group of students. Are we going that way? I don't know. But it seems so. It seems so. And why this particular transition, technological disruptions have happened for the last 250 years, at least, industrial kind of innovation. But this one is slightly different because this quote-unquote AI revolution raises some really important existential questions around how we acquire knowledge as human beings and the role that human beings play in facilitating learning for each other. And that's an important question. As an academician myself, the question that comes to my mind immediately is now, how do I structure the question paper to answer to your question? But the first question that really comes to my mind is, why rush? Why rush? And 3 days ago, we got an answer to that when there was a $500 billion loss in few hours. We got an answer that there is possibly some kind of overexcitement to see results too soon, too early. And that never goes down well technologically, at least. I'll stop here. I have a few more instances to share with you. Those are essentially sob stories. And then I want to really honestly, before I hand over the mic to my fellow panelists, I have one genuine question that I have brought all the way from Bombay for all of you, because I think the answer lies with you. What is it that you are looking for in these young lawyers that you will hire? What do you want? Do you want them to work like a machine? If the answer is yes, then we can buy a great one and we can build a great one. If you are wanting someone to have these attributes in JDs of integrity, trust, some of these things, and we can talk more as we go along, then we'll work backwards and fix our curriculum and our pedagogy and our style and our approach, along with the support of the Bar Council and all the other institutions in that sense. We are all interconnected in this. And it's our shared but differentiated responsibility to get this right. I'll stop here.
Thank you so much, Dr. Ashish. Now, we are a gathering of legal practitioners and academicians, so I think we need to take the opportunity to discuss the importance of experiential learning. Unfortunately, the legal education today in India largely is rooted in old methodologies, which actually focus heavily on memorization, case law, and precedent analysis, leaving very little room for practical, data-driven research skills which are needed for modern legal profession. And that brings me to Naveen. Naveen, what do you think, how can India legal education system integrate experiential learning to better prepare law students for the demands of today's profession? And how can legal education evolve to ensure that lawyers actually possess legal expertise, not only to understand business metrics, but industry dynamics as well?
Thank you, Shelley. Excuse me. And thank you, Akil, for the invite. It's a pleasure to be here, and thank you for sandwiching me between a general counsel and 4 professors. So I feel decidedly underdressed with this level of academia around me. Although I am a lawyer, I qualified as a lawyer in the UK. So my knowledge of the Indian legal education system is somewhat limited. However, I wanted to approach this question from 2 ways. Firstly, from one angle being a legal search consultant. So I listen to what my candidates in India are telling me, their backgrounds. I listen to my clients when they're looking for individuals, what sort of attributes they're looking for, skill sets, training, academic qualifications, etc. The other angle that I found rather interesting to look at this question was a more personal one, actually, from my son, who went to the UK to do his law degree, UK educated, UK born, but then after he did his law degree, did the LPC, the legal practice course in the UK, and came to India just over a year ago. And the Bar Council insisted that he had to do 1-year conversion course before he could sit the exam to become an Indian lawyer. And now he's working as a lawyer, but he hasn't sat the exam yet. But that experience that he went through under the BCI was a real eye-opener for both of us, and also for his friends on the course who I've met and spoken to. And so that forms part of my response to this question. I think that, and if I could share with you the list of grievances my son had with the way the course was run, we'd need a lot more time, unfortunately. One of the plus sides was, though, that they only had 1 venue to do this course, and that was Goa. So he enjoyed it. That's what's important. So first off, incorporating clinical legal education. Imagine the difference that law schools, if they were able to offer practical hands-on training like internships, moots, other experiential learning opportunities, and I think we've already touched on this already, that would make a big difference. An interdisciplinary approach where you integrate subjects like economics, psychology, history, sociology, etc., will give students a more holistic understanding of the law, make them more rounded as individuals, and hopefully give them a good grasp of business metrics, strategy, and industry dynamics. And this is also feedback from my son, updating the syllabus to keep it in line with contemporary changes in the world, technological advances, global developments, and emerging areas like cybersecurity and environmental law. And another big gripe that I heard from all the students was shifting away from rote learning, sort of just mesmerizing and repeating, but instead moving to something that's more analytical, problem solving, where there's critical thinking, and hopefully it sort of gets them more in tune with what they're going to have to be doing in the workplace. Something that I do in my business on a daily basis is competency-based interviews and assessments. So really sort of digging into practical skills such as drafting, negotiation, advocacy. These are better ways of tracking a student's growth and again, preparing them for real-world challenges. Establishing mentorship programs. There's so much experience just in this room, but across the industry in India, from lawyers, judges, in-house counsel, academics, that if they were paired with students more often, then it would give them a real insight into the different career paths that are open to them, and hopefully inform them much better as to which route they'd want to take. Upgrading infrastructure. and resources is also necessary. At this newly launched Goa Institute, there was no Wi-Fi. I had to pay for a library pass. There was no library. I mean, it was shocking, and the kids were complaining. I hope nobody from the BCI is here, is there? But it was shocking. There were no set term dates. There were constant absenteeism of the lecturers. And I think just upgrading everything is really important. And finally, strengthening the sort of regulatory role that the Bar Council plays. It should be transparent. It should be a way of monitoring the performance of each law school in a very transparent way so that students and parents alike can assess and compare and benchmark.
Sure. Thank you so much. I think that's a great segue to our next topic, which is...
Yeah. So I'll just, add on something to the experiential education. The way how it started, let's say, in the United States, experiential education is, let's say, for some students who don't want to read, and we started with that must be some alternative to rote learning. So, okay, you don't want to read, you don't want to learn, but then experiential education will be there for people who want to have a hands-on experience. But now we are adding on to the skill sets, the development of skill sets. So there are two elements. One is that for those who are not into deep reading or studying or research, they can experience at hand, the work. Then another thing is building of skill sets. So there are two aspects in experiential learning in India that we need to explore more. And I would like to mention here that the GCI has been kind enough to curate bespoke course for us. There was a startup mindset, and lots of general counsels came to the university. And it's not just legal education, it is, the steps in startups, the financial activities. And now we have set up a center for innovation, incubation, entrepreneurship, where the people, now what we are seeing is that after doing law, some of the law graduates are proceeding towards management degrees. They're also moving to startups. They're also creating startups. So it's not just about the skill sets, but it's also, we are trying to provide a situation, a simulation of a clinic where they can get a hands-on experience, inviting those field experts. So not only legal, but business and maybe technology as well. Thank you.
Sure. So I think it's a pretty similar question that I wanted to pose to Dr. Avinash, is the role of electives. Law schools traditionally, historical, have relied on permanent faculty, but now increasingly they are giving an opportunity to professionals to come and teach, and especially, niche areas like data privacy or technology law or, project finance. So Dr. Avinash, my question to you is, how can law schools design an effective elective system to prepare today's student for the modern world?
Thank you. So first of all, thank you very much for inviting me. I think today the objective of this conference and this association is to rethink, revolve. So we really need to go back in history and say what happened. So the law schools, which I think mostly we are graduating from traditional law schools, and then Madhav Menon model started. Definitely Madhav Menon model was not to help the corporates. It was purely for the social engineering. That didn't happen. Then eventually market opened. Definitely in 1987, nobody thought about that market will open one day. It happened. And those best of the best minds from India, they started moving to corporates. It worked. It worked for them. It worked for law schools because of the high placement, and the best of the best minds started going to those NLUs. And then there was a mushrooming of NLUs, private law schools. So the Madhav Menon model was purely for social engineering. So I think that we need to rethink. Second thing, that model didn't work, but the counter model worked. But now we are having problem with that counter model also, because that model is also collapsing. Most of the law schools are not able to produce those type of lawyers who can really serve the industry or academia or even the litigation, because that was not the objective of that model. So now maybe we need to create a new model. And what would be the that model? I think this is the model. We need to understand and redefine the purpose of law school. What is the purpose of a law school? If I say, and if you all agree, that the purpose of law school to produce quality legal professionals to serve the industry, then definitely we don't need law schools. We can adopt CA model. CA model worked very well. You don't have a CA school. You take their exam, you put them in 3 years internship, then take another exam, and after 4 or 5 years, I think those guys will be 10 times better than any law school graduate. So definitely the objective of law school cannot be only to produce quality lawyers. So what is the objective then? What is missing here? The missing point is that the purpose of law school is to serve the society. And when I say society, means not only the poor people, even the middle class, the business class. We need to expand the horizons of law school. And why it's not happening? I'm sorry to say, I take the blame as a professor and dean and director. We have closed our doors. Just a small windows like this. What you say, this modular teaching, this. Okay, you can come and teach this elective course. We will decide, first of all, who will come, who will not come. And you can come only for elective course. That's all. You teach and go. And the purpose of that, you will maybe come for internship and placement. That's a hidden agenda sometime, most of the time. We are not understanding the purpose of law school. We need to define. And that purpose is to serve the society. And how can you serve the society without interacting with them? How many times law school are inviting general counsels and try to understand what is happening in market? What are the problems? Please tell us. For example, in tax law, I am a competition lawyer. Okay. I was a competition lawyer. Now I'm a professor. How many times law schools are inviting competition law practitioners or general counsels and say, guys, please come and tell us what is happening in competition law? Not for our students. It's not like a guest lecture, come marketing and internship and placement agenda. It's inviting them and say, hey, listen, tell us what is happening in competition law, tax law, any law. Can we help you? Can we work together to do research? Can we work together, go for a proper policy recommendations? No, we don't do it. That's the point. So our law schools are closed because we believe as a professors and universities, we know everything. And because of our cultural advantage that professors, irrespective of their knowledge and skills, they get good respect in society. So nobody tells them, sorry, professor, you are stupid, you don't know anything. That's the point. So I think this elective model is good, but that's not sufficient. It's not serving any purpose. Okay. We need to open the gates. We need to open the gates for the working professionals, not only for electives. The journey must start from design of the law school. Defining the purpose of law school. What would be the purpose of this law school? Maybe my law school will serve X purpose, his law school will serve Y, and his law school will serve Z. Not necessary that we will go for the same objective. Maybe one law school say, hey, listen, we will go for more social dimensions, human rights, environmental good. Someone will say like me, hey, listen, we want to go for executive education. We want to work with working professionals to train legal and non-legal professionals. Maybe he say, listen, we want to do something X. So first invite them, have an open discussion, the purpose of law school, that's a point number one. Then the journey should start, not end. Then involve them in the design part of your course curriculum. Then invite them in your BOS, academic council, and even in your classroom. Why only elective courses? Why someone is not coming to teach tax law, company law, family law, criminal law? Why only these niche fancy areas like data privacy, AI? They are good. But why someone is not coming to teach criminal law? Why, like I think we should invite ma'am to teach criminal law in the classroom as a co-tutoring. That ma'am, I will teach theory because I don't know practice. You are best in practice. Why can't we teach together in the same classroom? Why can't we design our papers together? I think all these fundamental questions we need to ask, and we need to solve each other problem. Our problems are different, law schools. Your problems are different. We need to sit, understand each other, and try to help each other. If we talk, if we work together, definitely we will be able to not only produce quality lawyers, but we will produce quality faculties also. The problem with faculty is not with the students. How many law school faculties can claim, at least not in my law school or any other law school, I know many top class criminal law professors, can they draft a simple bail application? No. They say, no, this is not our job. We will, professor, we will teach. No, sorry, you have to evolve now, rethink. So I think this is a new era. We need to go for a new model.
Sure, thank you so much. So the discussion that we have had today actually converges on an important question of what does it take to be a future fit lawyer and how can we facilitate developing such lawyers? So my question to Dr. Gangopadhyay is that what are those additional skills beyond the traditional ones which are essential for lawyers today? And how can law schools adopt their curricula and teaching methodologies to basically equip the students with those skills?
Thank you, Shelley. First, I must say this is a very unfair question to me because I'm an imposter here. I'm not a lawyer. I never studied law. I don't teach law. And I'm not in a law school. So what I'm going to talk about is what I believe I would want in a lawyer. And by the way, I fully agree with what was said just now in the sense that law is a normative discipline, right? And therefore, clearly there is a goal, there is a reason why those laws are drafted. And therefore, it is the job of every student to understand, question, change, modify, all the things that was said in terms of experiential learning becomes relevant. And unfortunately, from what I see, since I've been on the advisory board of a School of Business and Commercial Law, so the two together, there are a lot of lawyers. I've been in various legal bodies also abroad. So from what I have seen, that there is something lacking in the legal, in the students of the legal profession here, in the sense that their understanding of the social sciences is quite limited. So law is also like an engineering discipline, right? So in everything we do, we take an engineering approach. To give you a very simple example, whenever we talk of mobility, there are very few people who say we need to move person A, from place X to place Y. Immediately people start thinking of roads, bridges, and all those things. So that approach has to change. And I agree that maybe, in a sense, though I'm a very big fan of Professor Madhav Menon. In fact, he's the one who got me into law. So I'm a big fan of him. But I do believe that this integrated program has affected the perspectives that many of the law students are getting. All these law schools are set up far away from the city. They're all campuses. They all meet the same people. They're all lawyers, right? Law professors. And imagine their kids, right? Their Chatajis are lawyers. Their Mausis are lawyers. Their Dadas are lawyers because the kids, they play with the students. They're also turning to be lawyers. This is a horrible way to bring up anybody, but that's what is happening. In fact, my biggest criticism about the way universities grow up in these faraway places in the cities, How can they connect with what is this experiential learning we are talking about, right? When we are making the campus the place where they're going to grow up. So, all the talks that we had, I actually agree with almost everything that was said. My problem is that we cannot start with law education. We have to start with education. We have to think through all these things, right? That what we want to do. And the fact of the matter is, for me, all the laws were made by humans, not God-given, not nature-given, right? It is we who have written down the laws, and therefore everybody has the right to question every single one of them. There is nothing that is given for us. Society is changing, laws need to change. If we don't know why that law was made, we will never know what to change, right? And hence it is important to start teaching law in a very analytical way, right? I've always felt I'm not a great believer in anything, but if I was born again, I would study law. Because I'm not saying it because you are all here. I've said it in public elsewhere too, even to my fellow economists. You know how economists are, right? We're imperialists in the academic disciplines, right? We take over everything. Everything that you say, we have something to say, right? But I've said it in front of economists too, because it's the only discipline that not only has a normative approach, which as a social scientist, obviously that attracts me, but also because it involves understanding of every discipline you can think of. Think about it. Legal philosophy, ethics, right? Analytical, maths, physics, today technology, right? You need to have a proper understanding of these things to be able to be a complete lawyer. And therefore, that's why I said, so I think it's one of the most important disciplines that a student can go through. And to just treat it as a practice, as a profession, which is what we are doing in India today. So it's a career. That's a horrible way to, I think, treat law. That's unfair to the discipline. I do think that we, take it more seriously and reorganize everything. All the problems that are happening is because of this lack of understanding. That law is something that is ours. We have to take charge. We have to, bring it about. We have to make people aware of it.
Thank you,
I'll just
sir.
stop there.
Sure. So thank you, Dr. Bajpai, for joining us.
Thank you.
Now, the theme of this event is rethink, redefine, and re-evolve the legal profession. And GCAI, of course, has a perspective, but it'll be very valuable to hear a perspective from an academician like you. So, your views, please.
First of all, thank you so much, Khilji and the team of GSI for having me today here. I'm extremely sorry that I got so badly delayed. You are right, sir, that law schools are located very far away. And that is one reason why it took me for almost 2 hours to reach. And incidentally, our Honorable PM was also there in that vicinity, so there was a lot of things. I don't know how we are going to cope it up, but you are certainly right. And just extending this conversation, as we often feel that while we have talks and the general expectations that lawyers should be seen more often to the university campuses, and generally it is not possible for them to find out that kind of time because of location, definitely, and the kind of schedule they have. That is one reason. But I am something on different. I have spent some 30 years in the university education at different places. I think we need to understand what kind of times that we are now witnessing and how those times are going to impact now the future course of legal education. And we also need to understand the linkages and the relationship of legal education and law profession, the manner in which they are now shaping. A new understanding is needed. If I draw a kind of synergy or a kind of similarity with medical education, the relationship between medical education and medical profession is so integrated, so interlinked, so institutionalized, so well defined. Therefore, the growth in medical profession is directly linked with the medical education. You will not find any medical college without having a hospital in the premises of that institution. The idea is
to nurture that idea of practice right on the campus. The integration has to be in a manner where things become, very, easy for, that easy adaptation. Incidentally, legal education and legal profession has never grown like that. The initial idea of legal education, whatever limited was it, just to sort of cater to the legal profession. Therefore, for a long, long time, you will not find many LLM courses to be on the campus. People they have no interest in doing masters or PhD in law because it was not needed. Generally, the lawyers in the morning hours before going to the court, they used to come to the university campuses and teach some classes, and the legal law colleges were not so well organized. That is one reason why the academic and research side of law has not developed in this country, the manner in which it has grown elsewhere. Because we must understand that a practice cannot develop unless theory is matured. Theory and practice relationship is very, very important. If you see, all scientific innovations are based on some fabulous theorization. So but recently, we have seen this change that legal education has been drastically refined and a lot of innovations are happening. But to what extent they are now catering to the law profession, that is something very, very important. I believe that there is a lot more institutionalization is needed in order to really attract the capable law student into in-house legal firm or law firm as such. For that, I have something to very suggest. See, if you see the government side, the services have been organized very systematically. Therefore, they are capable of attracting the talent from various institutions. The in-house law firms or in-house legal teams in the industrial sector, they are very unorganized so far as hiring is concerned. So it depends on a single law firm or a kind of organization who is willing to take law student. They would independently go, and the hiring pattern or attracting the talent from law school is a very, very vague affair, I would say. There is a need to now organize it like a service. There can be a very good organization of services to the corporate sector and industry sector from the law school, and that is possible. Only thing which is needed is to evolve a clear-cut policy and consensus. So like self-like organization, and there are many other organizations who are working, they should pay attention, and all the industry and law firms in-house teams should come together to develop those hiring. And they also create the hierarchy of people that they intend to pick up from the law schools. And they also decide the perks and payments and all that. And if this sector can be made little more organized, I think the law student will be very willing to go to these sectors, and there would be a lot of clarity. Second, when we talk about the nexus between the profession in terms of people going to the law school, that is also very, very ad hoc. So sometime once in a while or once in a blue moon, a senior lawyer goes to the campus and gives some lecture and come back. This is important, but it is not very much integrated. At National Law, I teach at the National Law University, Delhi. I work there. I'm telling you, we have created a system that is called Abhyas. Abhyasa is a segment that we have created whereby we are attracting the law practitioners who could come in the afternoon to contribute to the syllabus, not general lecture. And we will discuss the issue with beforehand, that what practical aspect you will teach to our student. And then they come prepared and they contribute to that syllabus of that, whether it is contract or tort or criminal law or IP or anything. But it should contribute to the practical learning. I am telling you, this is happening. And the lawyers who are coming to teach, they are very young lawyers or middle level lawyers. And they come with a lot of passion and engage the student in the late afternoon. And this affair, the characteristics of this engagement, that it is systematic. Systematic would mean syllabus is known, delivery is known, monitoring is known, evaluation is known. So therefore, there is a lot of integration. As a result, the student get to know the practicalities and the possible requirements of the sector, so that they could prepare themselves in those terms, in terms of contributing to the industry in different sector. So I think a lot of institutionalization is leaving. A lot of talks and talks and talks is not going to be very, very helpful. So we are creating, like, I think last month we have incorporated NLU Delhi Foundation, we have created Section 8 company. And now we are actually incubating so many startups within the university. We have signed, in fact, we have already incubated a couple. Now, Nyaya Sutra is one app which we have created with the help of Consello AI. If you search, they have tremendous solution to the ministry, to the law, to the courts. Now, we are coming up with a very customized solution to a number of problems that the ministry, governance, and these sectors are facing. Now, it would result into a lot of mobilization of the student in terms of taking their interest in technology and thinking of those solutions. So now technology is going to be a very important solution. A lot of redefining is needed, the way the legal profession is working and the way the legal education is working. You have to prepare these students to be ready for 21st century lawyering and 21st century profession. For that, you need to bring that kind of empowerment. And I believe AI solutions are going to be the game changer now. What the law schools are doing, what the law profession is doing, this is something to be seen. If I don't know, it doesn't mean I should be registering it. I should be promoting it. I'm telling you, many people say, why you are not now looking at criminal law, IT general. I am reading only AI these days, law and technology, only law and technology. And I'm talking more and more with engineers, are the experts who are AI expert. And I am very willing to sort of take up, and this NLUD Foundation will make at least 50 startups to be incubated. I have appointed a CEO. Now, CEO is working with various industries and sector. We need. And I am interested in only in legal field, that what solutions can be given to the legal profession and to the policy work, and how the legal education can be reshaped. Now, this is the future. So I am very strongly believing that the time has come that we should change our pedagogy. Pedagogy is going to change. All law schools are now asking the student to do the project. Today I had a meeting with my colleague. I said, art of writing and that craft of preparing the document is no longer a benchmark or assessing the skill of a student. Now AI can do it much better. You should think something else now in terms of creativity, in terms of innovation. So innovation, creativity, and that kind of risk-taking is something which we should teach. And I wish that we should have some faculty from engineering and management to be on the campus, which I am already taking. We have signed MOU with the IIT Delhi and also with the NSUIT. And we are having now professors for that purpose to facilitate. And I think then we will be able to give a lot of solutions to the industry, the work they are doing, with a better set of students and a skilled set of students who would contribute from day one in a very innovative way.
Thank you so much, Dr. Bajpai. We are really out of time. Let me just close by saying that we need to have an active partnering between the legal professionals, the GCs, and the law schools to truly reform and transform legal education in India. Thank you, everyone.
This is definitely a session that was much needed at today's day and age. Thank you to all the panelists. To give away the mementos, I would call upon Dr. Akhil Prasad, founder GCAI, board member, Group General Counsel, and Company Secretary, Boeing India. I would also request all the panelists to please come together for a group photo. Thank you so much, everyone. I would just like to bring to everyone's notice that on behalf of our partners, LawWiser, we would want you all to help us with a survey. They have launched the 3rd edition of the GC Insider Survey today. These are available as flyers given to you all while entering. These are also available on your round tables. Please do take out a few minutes to scan the QR code and give your inputs on the GC survey. We thank you for adding value to our research. With that, we would now like to welcome Dr. Lalit Bhasin, President, Society of Indian Law Firms. Dr. Bhasin has over 6 decades of experience in the legal profession. He is the managing partner of Bhasin & Co. and has held numerous prestigious positions, including President of the Bar Association of India and is President of the Society of Indian Law Firms. Dr. Bhasin has been recognized for his outstanding contributions to the legal profession, receiving honors such as Plaque of Honor. All right, it is my second time welcoming you, sir, on the stage, so thank you so much. Please come.
It is a great pleasure and privilege for me to be here once again. Since I attended, you see, the very first inaugural function of this great institution which you have started, that is the GCAI. Very much needed, and it brings in, you see, some fresh thinking, not only about the role of GCs and in-house counsel, but generally about the role of the legal professionals. Before I say something on which what I've been preaching, you see, and saying and stressing, that the recognition which the general counsel, in-house counsel deserve, it has not been given to them. But before I go to that, I was a bit intrigued. I apologize, Professor Dadichi, when you said the purpose of the law school. Purpose of the law school has to be to bring out trained students to become good lawyers. Whether they become lawyers in the courts, or they become general counsel, or they become law teachers, or they join some NGO, that is a different proposition. But it is inherent in this profession that we give to the society. We serve the society. Therefore, you don't have to teach the law students that the purpose of law school is to serve the society. Purpose is firstly to train yourself to be good lawyers. That service element automatically comes. Was Mahatma Gandhi trained in a law school to give it to the society? Was Sardar Patel, Dr. Ambedkar, Dr. Rajendra Prasad? That was pre-independence. Did they join a law school, you see, with the purpose of that they have to serve the society? No. It is inherent as lawyers, as professionals, that we have to give to the society. And it is there. In our Advocates Act, it is there. In the Bar Council rules, it is there. Therefore, the purpose should not shift, that you create another area of how do lawyers serve the society. Even post-independence, we had 12 presidents of India who were lawyers, about 7 prime ministers who were lawyers, 7 speakers of the parliament who were lawyers. And of course, we see so many eminent lawyers becoming ministers. Whether it is this government or it was the previous government, lawyers have always played a very important, significant role in serving the society by giving up their lucrative law practices where they could earn lakhs and lakhs of rupees per day. But you see, joining either the government or trying to serve the society by becoming speakers or in other so many capacities. Therefore, as I said, I was a bit intrigued when you said the purpose of law schools as envisioned by Professor Madhav Menon, and I had the good fortune of working with him during my 63 years of law practice, you see, of working with him closely in the field of legal education. I have been on the advisory board when he took up the National Law School at Bangalore. The model which he introduced is responsible for being called as the father of the modern legal education. The national law schools which have come up, we have Mr. Vajpayee sitting here as head of one of the most eminent law schools. They all arose out of a big thinking, big planning, which was duly considered, you see, by the authorities also, and that is how these universities were set up under state legislation. So that is the purpose, you see, of the law schools. One more thought, you see, I have is about these 5-year courses that you have. My experience has been that the 3-year legal course after you graduate from a college was a very vital part of your overall education. The personality growth of a student, you see, it blossoms, you see, when you go to a college. You study history, you study economics, you study, you see, social sciences, you study so many things. It helps in development of your vision, development of your personality, which would then be a major factor in your becoming a good law student when you join a 3-year course. What is happening now? From a school where we start, you see, with the kindergarten and go up to the 12th class, and then straight away we are sent, you see, to a highly professional law school, 5 years. Where is the scope of a growth? You are only considering, you see, what is the Contract Act, what is the Indian Penal Code, and all those laws and all that. But the personality doesn't develop. Our predecessors in this profession, they studied law, but also studied, you see, what was the literature, what is the history, what is the culture. Whether it is now even Mr. Venkat Ramani, our Attorney General, he's a scholar, he's a jurist. Mr. Venugopal, Mr. Fali Nariman, Soli Sorabji, they could quote Shakespeare and so many other, you see, things that arose out of their knowledge, not just about law, but they studied so much, you see, in the colleges also, which helped in growth of their personalities. Coming to the role of the General Counsel, I am reminded that when Mr. G. Ramaswamy, he was demitting his office, so we in the Bar Association of India hosted a farewell function for him. And while addressing us, he says, I don't know why you people give me farewell. Today I am Attorney General, tomorrow I'll be a General Attorney. So it is the same thing, but the distinction lies in the expression general. What do you mean by general? It has got two meanings. One is a general thing which is applicable to all, as a group, as a society, common for all everything. Other is a general who leads. And I was quite surprised when I was looking into it. 1961 edition of Webster dictionary, it defined, you'll be surprised, it defined that who is a general counsel. Webster 1961 edition. Just have a look at it, see general counsel. In India, people didn't know who's a general counsel, you see. Possibly they could have misconstrued it as something to do with army's council, general counsel, you see, for the army or something like that. But this is how it was defined. GC, a lawyer. Words are very important, because the Supreme Court says when you are interpreting some provision, you should give it the ordinary meaning, dictionary meaning, you see. Then it says a lawyer at the head of a legal department, as of a corporation or a government subdivision. So you are not a general attorney, as Mr. Ramaswamy said. You are a general counsel. You are heading, you see, a proper legal team. That is way back in 1961, possibly earlier edition would have carried out. But this is the definition of general counsel, and recognized even in under our constitution. What is the role of Attorney General? That is the constitutional position in our constitution. He is the law officer of the government. So he is on the payroll of the government. Is he not allowed to practice in the courts? He is in employment. He is in employment of the government. He serves the government. He appears for them in the courts, advises the government. Same is the function with regard to Solicitor General. And these days we have scores and scores of additional Solicitor Generals spread all over the country, you see. They are paid. Why can't we call them paid employees? But they are paid lawyers. Apply the same logic and same principle, you see, to the role of the general counsel. You are employed, you are paid, but according to Webster, you are a lawyer. Important thing is that you are a lawyer. If you are a lawyer, then you have a right to practice. Possibly, as in the case of law officers, they need to take permission from the government if they have to appear for a private party. Even appearing for private parties is allowed, subject to their getting approval from the government. Why can't the same principle, same logic, same rationale be applied, you see, to the general counsel who are admittedly lawyers and who perform legal functions of advisory natures to the respective corporations they represent? And there has been a sea change in the role of general counsel. They are not just like rubber stamps. Okay, this is what the board wants, we will approve it and give it. I have seen, that is my experience, particularly during the last 10, 12 years, the general counsel are asserting themselves even against, you see, the decisions or the recommendations of the board of directors, telling them, okay, you go to this, but this is the extent to which you can go. You can't go beyond that, because then it would be infringement of law and then consequences will follow. That is the emerging role of general counsel, which I see now, and that is a shining example of what can be done, what can be achieved if general counsel do really advise. We have taken up the issue again with the Bar Council of India. Mr. Shardul Shroff is here. He's been a very integral part, you see, of our discussions on various issues with the Bar Council of India. And this is one of the vital issues which we have taken up. Why don't you recognize, you see, the General Council as lawyers who can, at least to start with, represent their own corporations, institutions, companies before the courts. And so far as knowledge goes, I think you are second to none. We are external lawyers. Some issue comes to us, we will apply the latest AI research tools to find out, okay, what is it and all that, and we will do that. But you people deal with diverse problems which you see the corporations face these days. It is not just confined to one intellectual property issue, you see, or a IT related or tax related. You deal with so many aspects of, all aspects of governance, functioning, operations of your respective organizations. Therefore, knowledge-wise also, you are second to none. As a matter of fact, if I am appearing for a corporation, for a company, I would like to be assisted, you see, by the General Counsel, by the in-house counsel, the team, that will look here, this is the problem, this is the issue, these are our work practices, this is our work culture. Now, how do we align, you see, the requirement of law with the implementation of the objective for which the company or activity has been set up? That is where you see the role. Therefore, I will not speak more about your role, because that, in my view, is very, very significant. It is unequaled so far as the economic growth of the country is concerned. Because General Counsel, they advise the corporates, you see, to sign the MOUs, to sign joint ventures, M&As, transfer of technology. The starting point, you see, is it's with the General Counsel. So to provide that big economic support to the country, the role of General Counsel is very, very significant, and it cannot be, you see, minimized in any manner. We are there to actually assist you. You are not there to assist us. Yes, we may be doing some criminal cases, there we may not need you. But in all corporate matters, but even in criminal matters, you see these days the blue collar, white collar, blue collar, various collars, crimes and all that, everyone is involved, you see. So, therefore, my humble suggestion is, don't give up on this. Continue the fight. Possibly, I see no reason why you can't file a writ petition saying that we are lawyers and we act as General Counsel. Yes, we are in the employment of a corporate body. Why can't we appear for our, you see, corporation? If the law officers can appear, who are also employed, why can't you be appear? It will be a good test case, you see, if you were to initiate something. But first take it up administratively. I see the program that the law minister is coming. I don't know whether he'll come, but if he comes, you can take it up. He's already, I think, seized of the matter, but at least start with the Bar Council of India. We are already in dialogue with them, and we would even arrange a meeting for your 3-4 top representatives of this wonderful organization to come and share with us. So those are my views, friends. It was a privilege to be here in the midst of such eminent and galaxy of General Counsel and also senior counsel like Madam Pinky Anand and Mr. Shardul Shroff and so many other colleagues from the profession and the academicians like Professor Bajpai and others. Thank you very much.
Thank you so much, Dr. Bhasin, for your encouraging words. I would now call upon Amar Sundaram, founder, GCAI General Counsel, Senior Vice President, Legal and Chief Compliance Office, NEC Corporation, to give away the memento. Thank you so much. Thank you so much, sir. We now move towards the crux of today's event, a session that many of us had been waiting for. This session is recognizing in-house counsels. I would like to welcome on stage our panelists for the session, Dr. Pinky Anand, Senior Advocate, Supreme Court, Dr. Shardul S. Shroff, Founder and Executive Chairman, Shardul Amarchand Mangaldas, Amit Singh, Partner, Head of the India Group and Head South and Southeast Asia Capital Markets, Linklaters, Harsh Pais, Partner, London, A&O, Shearman. This session is moderated by GCAI member Rakesh Kumar Prasthi, Group General Counsel, OYO. Please join us on stage.
Thank you so much. I think I'm totally enlightened with the last few sessions, and I feel like my job has been actually made very easier. With the speech from Mr. Dhanendra Kumar, Mr. Gupta, and the galaxy of all the professors, especially Mr. Dadich, thank you for enlightening about what is needed for the school, and probably that made me make some change and amend for my discussions here today, to be very honest. And I can't thank Dr. Bhasin enough, because I think he has actually made this community actually much more empowered and much more accountable to that extent, actually, to be very honest. So coming back to the interesting topic of statutory recognition of in-house counsels, I think I would actually take a little bit of pause and check with this group. And probably it will be a show of hands. How many of us actually here gathered who are, sorry to ask this question, but who are on the other side of 50 and who are on the behind 50? Can you please? Now I'm just requesting this group to answer. This is an interesting point, because the situation is, are we actually fighting for the in-house counsel, or probably discussing this topic for in-house counsels, or you are talking about the next generations to come? And if that's the situation, what are we trying to do here? Are we talking about the GCs here? Are we talking about the students who are actually getting enrolled in the schools, thinking, am I going to be a practicing lawyer versus a corporate lawyer? And I can very well say that with my limited number of visits to various law schools, the law school students do not know and do not have the insights of having a corporate lawyer profession. So probably that's a significant amount of ignorance that we are suffering with today. Second point is, all of this group here have somewhere either done the practice or they are actually doing corporate law themselves within the part of the corporate. I myself, a general counsel for OYO, have been in the industry for almost like 29 years now. My only point for discussion is, are we going to boil the whole ocean to make all of this recognition today? I don't think so. The question is, Are we talking about a one-way street, or it is a dual street? It's a two-way street. Is this a profession of fungibility? Are we talking about a in-house counsel, can he go and practice law, versus a practicing counsel come and actually practice a corporate role? Right. We are, I think, in the amount of the number of counsels and the number of advocates practicing in the country, roughly about, I did some basic research, about 2 million advocates with about less than, or maybe borderline here and there, about 100,000 in-house counsels. And maybe some of them will actually try to practice law. Maybe we're talking about 20,000, or maybe 10,000, 20,000, 50,000. The actually contribution for the in-house counsel to actually become a practicing counsel is not more than 1% today, or maybe 2%. And why should we clip their wings when an exciting profession is waiting for a student who wants to go to the law school, say, I want to actually practice law, I want to practice corporate, I want to be a part of both the ecosystem. Today, it is divided by a definition of salaried employee. I'm sure we have many wherewithals to fix it, but can we actually make this system fungible? With that, I will request Mr. Schropp to throw some lights about what is your experience, sir, with the in-house counsel and the general counsel community. At the same time, their ability to navigate the larger legal ecosystems and their ability to navigate that. And second, are they entitled to certain privilege which they are not today, and how is it actually disrupting? In the current scenario, disruption is the way of life, but are we allowing this disruption to go much longer, to hurdle us and create bottleneck for us, rather than developing for growth?
Thank you, Rakesh. In my view, this problem is not a problem. And let me address it logically. Today, a person who has done a 3-year course or a 5-year course and completed it in the 3rd year, passed an exam, and cleared effectively his registration with the Bar Council of India, is an advocate. A person who goes through an examination of the same kind as the category 1 could technically be treated as an advocate as of the date of his enrollment. He need not be a lawyer. He need not be an advocate as of that day if he doesn't sign for his representation and his ability to be registered on the state rolls of advocates. The third equation which comes in is that instead of going into the profession of the law, he enters into an employment contract on a full-time basis or a part-time basis with any person, firm, company, government, and does not therefore become eligible to be a lawyer. In all 3 cases, the examples that I have given, the passing of a law exam is common. You have to pass the law. In the first example, you complete the law, you get a set of sponsors, and you go and register. In the second set, you choose not to register because it was a part-time action for you and you didn't want to be ultimately registering as a lawyer. And in the third type of case, you chose to be in-house or you chose to be a lawyer of a corporation. Now, if the person who is the counsel does not surrender his license to practice and suspend the same during his employment, he can practice as a lawyer. he can represent as a principal to principal basis of being an employee in a law firm. And consequently, he can be an employee of any corporation in India, or for that matter, wherever he has a right to represent as a lawyer. What is the distinction between representing as a ordinary person versus representing as a principal? There is a significant difference when you say that an individual who has passed his law represents himself as a principal in relation to transactions, corporate deals, any kind of legal work with another lawyer. This type of transaction is where he is representing himself as a lawyer and not as an employee of a corporation. So if you twisted and turned all these processes upside down, if you re-evolve the equation and state that you are not taking employment, you are apportioning your time exclusively for one client, you are getting paid compensation for your services rendered, then you are allowed to carry on the profession of law. And there is no power on earth which can stop you from practicing the law. Let me take the issue of the attorney-client privilege under the new BSA Act, as it's known. The previous version of the law in the Evidence Act had a confusion of who constituted the person who was entitled to the privilege. They had used a lawyer, they had used the word vakil, they had used the word barrister, and it was a set of people rather than one person. The amendment which has been made now refers to an advocate, and it refers the practice as a service. An advocate is also rendering a service to his client. So you are, as an advocate, entitled to an attorney-client privilege, but for the fact that if you had participated in the wrong, if you had been party to any proceeding where your evidence was necessary, then the privilege does not apply. But it does not apply to me also. If in circumstances where I was a party to that wrongdoing, I am not entitled to privilege. So there is both the concept of privilege and the concept of representing as an advocate. You have to just avoid this question of employment. You have to avoid being an employee of a company. You must be acting as a principal to principal basis, and you've beaten the problem. Because the two issues which are facing you are, one, can you be an advocate versus can you be just any ordinary citizen? And the second issue is one of privilege. Both are addressed by this particular theory or the approach to the problem. It does not require you to go and ask the law minister. It does not require you to go and see anyone for that matter, because you can do this on your own. You have to contract on a principal to principal basis. You have to give exclusivity to the law firm or the XYZ company which engages you, and that's it. So I really don't understand what's holding you up.
I think I'll just add up a small point here, sir. I actually, for the sake of a deliberation, I have kept last 5 minutes for a Q&A for 2 questions from the audience here. So I'll get back on that. Taking a cue from that, sir, on the privilege, there is, of course, there is a bit of fluidity on that about the in-house counsels who are salaried employee working exclusively for a company. Are they entitled to that privilege? And there has been many questions and different views and opinions. But I'm actually flipping a position here to Amit here. Amit, you have been practicing globally with multiple hats, raising debts, participating in equity market, talking about disclosure documents. You always say that disclosure document is like your blank check to escape any risk and liability. And then there are underlying opinion from the general counsels or the third-party counsels who are engaged in the process. How do you distinguish in this kind of communications and different geographies? For example, if it is US, your task is much easier. But if it is India, your task is comparatively tougher today. And the reason I'm making this is because US, UK, Hong Kong, to some extent China, these are the geographies who have seen some changes on the entitlement or rather benefits of having that privilege or rather ability to practice on behalf of the company, not as an authorized representative, but more as an advocate for the company or a counsel for the company. What's your thoughts on that? Maybe you can share some global expertise.
Yeah. Absolutely, and thanks very much, Rakesh. I think it was very interesting to hear Mr. Shah as well. I guess one question, maybe come to that later for him, before I... Is this better? Okay. All right. So I was saying maybe one question very quickly for him before I address the question that Rakesh has posed to me is, and I understand what he's saying, that you've got to avoid being an employee. But is that practical, and is that how really some of these contracts are structured? Because I think the problem is, I think most are employees, is I think my guess, right? And therefore you run into all these issues. So I completely agree. I think your legal analysis is right, but I guess the question is that really possible or pragmatic in the way it sort of actually functions on the ground? I'll be interested to hear your thoughts as to how people can perhaps find a solution there. But look, if I look at what I do, and I'm a New York and English law qualified lawyer, and I've sort of practiced sort of various parts of the world now in Singapore. I mean, the English law position is pretty clear, right? You are a solicitor, even if you are within a corporation, and as long as the principal matter of the communication is the provision of legal advice, your communication is privileged. It's very simple, right? So this whole complexity that happens because of and people here who are Indian lawyers are a better place to talk about it. The Advocates Act and Evidence Act and all the rest of it, whereby you lose your ability to be an advocate as soon as you become a salaried employee. And again, there are people who know Indian law much better than I do, but I know there's a case of Satish Kumar Sharma where someone did say that, well, if you're a full-time employee, you're not an advocate, and therefore the privilege for the in-house counsel wasn't respected by the court. But in England, as long as the principal communication is legal advice, privilege is retained. There is a nuance, though, which is that you need to distinguish your business correspondence from your legal correspondence. So if you are, for example, corresponding such that it isn't really clear if the principal purpose is really the provision or giving of legal advice, but really a commercial discussion, then privilege may not be invoked. And which is why we always say it's good to separate your correspondence relating to commercial discussions from those where the purpose principally is the provision of legal advice. Now, in the US, it's very similar to the English law position, but the US position is actually not as good as the English law position because, first and foremost, as you all know, there is nothing called US law. It's all state-driven, and every state is different. The other bit is that in the US, what you have is the subject matter test. And that test has a number of prongs, right? I'm not going to, I've spoken for quite a while, so I'm not going to continue for much longer. But it is essentially goes into things like the commercial purpose is the giving, receiving of legal advice, very similar to England and Wales. The subject matter is within the scope of employees' duties, and the communication was not disseminated beyond individuals who, because of their position in the corporate structure, needed to know its contents. But there's another bit to it. So in some other states, there is a control group definition of where privilege would attach. And there it says that if the employee who's communicating with a lawyer, only if he or she has the ability to take action on the advice of the lawyer is privilege respected, which means that if you're a senior enough person, so maybe you're part of senior management, so in some ways a bit more restrictive than England, but similar concept. But I think the confusion really comes because of, in some ways, to what Mr. Shroff was saying, because of Vakil and all these other words which have been used, and, in the context of you need to be pleading in a court of law for you to be considered an advocate, which obviously is not the way, I think, in the jurisdictions that I'm qualified in, privilege works.
Thank you, Amit. I think that's a good insight about both US and UK. But taking forward that from the perspective of disputes resolution for now. And Harsh, you told me you are a litigator first, then you became corporate. What are the situations that you have seen where in cross-border disputes, you have one US counsel having that privilege, having significant amount of, Google is listening, that's absolutely fine. AI is as... At least we know it's privileged. Yeah, it's privileged. So, it works, yeah. So, in that scenario, what is the disproportionate benefit that you think that a US counsel will have versus an Indian in-house or a counsel or a general counsel? And most importantly, from the perspective of a high-stake discovery matter, because discovery is a very critical, complex, cumbersome, expensive process, and you go through the whole of the things, and then suddenly you say that the US counsel is privileged and he is not supposed to produce the advice that he has received or he has given, versus the Indian counsel has to provide those on the piece of paper, on a piece of platter, on the dispute, and it makes them completely disadvantageous as far as the dispute is concerned. What's your take on that?
Sure. Firstly, thanks, Rakesh, and thank you for the opportunity to be with this eminent group and before this eminent group. I think that's probably one of the most important aspects of this discussion. And we have to keep two things in mind, that the in-house legal practice is the fastest growing avenue of practice now. And increasingly, the role played by in-house counsel and general counsel in India spans both matters in India, but also overseas. And therefore, having the protection of privilege at an international standard is important, because the operation of legal departments is most often it's integrated. And you might have lawyers from different jurisdictions contributing to an issue within a corporate organization. So when it comes to privilege, and I think Amit has summarized well the principles that apply, one of the key tests is the predominant purpose test, which was obtaining legal advice, the predominant purpose of that communication between the general counsel and another person in the corporation. And in US federal law, there is both state law and federal law. And in state law, the principle of privilege is usually codified in each state. In federal law, interestingly, it is codified in evidence law, but it's actually so well entrenched in common law that it applies with its full force, even though it's not specifically codified in federal law. And it is recognized not just by courts, it is also recognized by enforcement agencies and regulatory agencies. the objective of privilege is to ensure that clients can get timely and frank advice from their advisors. And the first port of call is the general counsel or the in-house legal department. Now, if there is a shadow of litigation or investigation with respect to a matter, especially in a cross-border matter or a matter that involves multiple jurisdictions, it's sometimes hard for lawyers outside India to fully grasp the idea that actually the principle of privilege might or might not fully attach, or at least there is some uncertainty about it. And litigation in India or a regulator in India could easily have access to that information. And as Dr. Shroff said, there are some well-established reasons why even in any country there would be an exception to that. But in every other circumstance, it handicaps the organization actually from being able to address legal issues in time. And even worse, in litigation, it handicaps the organization from getting frank advice from the team that is best placed to answer those questions. So I think the difference in the privilege protection probably is the most stark aspect of this particular problem.
Thank you, Harsh. That actually takes me to bring another thought on this, that we can all talk about privileges, but that also comes with accountability. The accountability of understanding the nuances of practice, the ethical standard, which of course the in-house counsels do follow as well, but at the same time how to bring the professional etiquettes of the courtroom, the professional etiquettes of the practice, and understanding the nuance. Ma'am, would you kindly share your perspective on how do you think that a budding counsel from the corporate be empowered to take this challenge, even practicing in a courtroom or getting the benefit of the privilege? But what he must do, which probably he has learned it from the law school, he has learned it from the business, he has done it on a day-to-day practice, but he has not done enough probably in a private practice. So what are the guardrails, do you think, that in the evolving system that we should have when you are actually making this enablement possible? How do you think that they should navigate that complexity?
I'm still struggling. But at the same time, that's in the lighter vein. But I was hearing the earlier speakers, and I found it very fascinating, actually, some of the re-evolution, and of course, Dr. Bhasin's ever-reaching, I mean, I think we must call him the energy head of the legal profession, because he's always heading either for the legal professionals of the foreign law firms to come into India, for general counsels to be recognized as counsels. So, I mean, ultimately, I'll tell you, this navigation is a very difficult steering course. And that is because of the vicious circle. You're not allowed to practice as an advocate. You're barred under the rules as it exists under Rule 49. So you don't enter into that arena. Law schools, as we've just heard in the last session, don't really give you the necessary wherewithal and the necessary tools to really navigate the surface. And the best way to navigate the surface is actually to be there. So, I mean, that's the best possible statement I can think of in these circumstances. I'll tell you, for example, very often, if I'm in a court, which I'm not regularly in, I will sit there in the court for a while. I will actually see what's happening. I will hear what's happening. I know, and I will come to know what the judge is thinking. But aside from that, the practical problems, I think the way the general counsels, for example, and I've had this dealing with lawyers and general counsels, there are issues, there are complexities. And I know that there is a resolution to it, but it keeps happening again and again and again. And the only way to know it is if you're the general counsel, for example, is part of the entire process and is able to implement. A lawyer can't. A lawyer is doing service for a client. You can advise, but at the same time, there is no follow-up sequence. So I think the necessary tools on that part are definitely with the General Counsel. And when, again, I was just remembering when Dr. Bhasin was talking, there's a judgment, of course, which he had not possibly cited and he must be doing about it, the Vijay Metalworks case.
Yeah.
And in the context of salaried employees and the comparison to the legal remembrancer, ultimately. In my opinion, therefore, a paid or salaried employee who advises his employer on all questions of law and relating to litigation must get the same protection of law. And therefore, any such communication made in confidence by his employer to him for the purpose of seeking legal advice or vice versa should get the protections of 126 and 129. In Tirath Ram, the learned judge has observed a communication made by a legal remembrancer of the government is privileged under section 129. With due respect to the learned judge, I am in full agreement with the position. I therefore hold a salaried employed who advises his employer on all legal questions and also all other legal matters would get the same protection as others under sections 126 and 129 of the Evidence Act. And even otherwise, these communications are properly covered by these sections. And I think this is the manner in which we should go. I'll tell you another example. It's when GST, for example, was imposed, and everybody was up in arms, particularly advocates, about the imposition of GST, saying this is a professional service in the cause of justice. So the practice of law is the cause of justice. You are not only answering to your client, but as Mr. Soli Sorabji said, as the Attorney General of the country, and he said this on a to the press and the media, I am Attorney General not for the government, I am Attorney General of the nation. And similarly, every lawyer is actually ultimately appearing not only for the client, but for the cause of justice, which is what we hold uppermost, this integrity, this ethos. I think these are some of the classical lessons that we do need to go around. Now, what does, I think, happen traditionally with general counsels, and I don't want to be sounding as if I'm not in any manner agreeing with what Tirath Ram, it was held in Tirath Ram's case, but basically, ultimately, a general counsel is more responsible to the company which he or she represents. And there's a very large cross-section of GCs today. I mean, there's apparently, the figures indicate in 2023, you have about 65% general counsels in companies over 1,000 crores. And you have a larger number in companies which are under that time scale and the pay scale, so to say. So you do have a large responsibility to your company. And you would, in a sense, rightly or wrongly, and I'm not commenting on it otherwise, but you would ultimately be a mouthpiece of the company because that's a cause you primarily represent. So your entire ethos works in that system, whereas the ecosystem of a lawyer does work differently. I'm not saying that we're not loyal to our clients, but I'm saying at the same time, we do look and see what is right and what is wrong, the black and the white, and the gray, of course, is always there somewhere in the middle. So these are some of the essentials that you do, but at the same time, GCs are equally qualified. You have every possible knowledge and you have more knowledge because you've dealt with an issue, you've dealt with the company, you know how the entire process goes. Now today, companies are growing. They're growing from small companies to big companies, startups, SMEs, MSMEs. So the whole process of this gearing up to the Viksit Bharat of 2047, I mean, that's where the whole conversation is going. So you do need to have the ability to represent, and there's no reason. I mean, we are talking about literally pre-partition days where you had this bar. I think it's more a matter of choice. I think we should give the recognition to general counsels to practice. Whether they want to or they don't want to is ultimately a matter of their choice. And that is what legal ethics also teaches us as far as ethics of law is concerned.
That's perfectly said, ma'am. I'll just add on a point and then maybe I'll open the floor for a couple of questions. You rightly pointed out, I think the lawyer's profession is the profession of, not the profession of law only, it's the profession of justice. So if we are actually getting budding lawyers from the new generations going out of the school, I don't know whether we should keep them under the restriction that I'm going for a private practice or I'm going for the corporate employment. Because at whatever said and done, today the Bharatiya Sakshya Sanhita, which is the Evidence Act, 132, 33, 34, all of them restrict their ability to keep their information confidential. They actually do not allow, it is only for the legal professional or it is the practicing lawyers. It is not the salaried lawyers. And very tricky nuance, we are all lawyers, so we are all innovative in terms of how to structure. So if a company today creates a retainership consulting arrangement and have a full-time employee through a consulting structure, that person can practice for the company. But that company having a lawyer as an employee, he or she cannot practice. Very, very simple, nuanced one. I think with this note, I think why not we try and see to empower, at the same time make them accountable, because that will come with significant amount of responsibility under Section 49 of the rule 49 of the Bar Council rules, right? Thinking about if we make any change on this, actually that requires the Bar Council's resolution, at the same time the Chief Justice of India's concurrence. If we do that, I may maybe making an open point here for the floor to ask a couple of questions on how do you think that this set of people, along with their respective teams, are going to make them fully responsible to do justice to what they will do in the court or as a responsible practicing lawyer?
I'm a general counsel of the for the last 10 years, I've been practicing. We are conducting in-house arbitration. We are appearing for 205 exemption, 317 exemption on CRPC. The only criteria is read Section 32 of the Advocate Act. What it says, you simply file an application before the tribunal, before the court, and 99% cases we are allowed to argue. And they are very happy if the general counsel. We have recently got a 130 crores award against railway, all in-house. So, of course, we need a statutory recognition. That is important. But you are allowed. You invoke 32 of the Advocate Act. It's very clear. Even non-lawyer can argue by moving an application. Point number one. Point number two, Pinky, I completely agree that the conflict or the no protection is available to the general counsel. No, protection is available. There are many cases of the High Court and Supreme Court, and the recent case is, where I was the witness also, is the 2G case. DOT Chief Legal Advisor, he was protected because of this privilege. Only caution to the general counsel, those who are budding or those who are matured, that you have to give a very reasoned opinion. Cite some judgment of the Supreme Court on a delicate issue. See, I know that most of the chairmen and CEOs these days do not like to have 5 pages judgment-like opinion. They want only 3 lines only. Oh, Hemant, tell me possible or not possible. But as a mature GC, you must give a reasoned opinion. You are fully protected. That is my view. Thank you.
My name is Rajiv Chauhan. So I was a practicing lawyer. I did corporate for about 35 years. I'm back into practice. And quite honestly, nothing has changed for me. And I can say that. And I think lawyers and corporate counsel, general counsel, I think they have evolved over the years in terms of need of organizations, need of practice, etc., etc. I think it's time the regulators evolve. That's the only comment. I mean, they need to understand this change which has happened, and they need to evolve, they need to change, and they need to have a very different outlook and a fresh outlook of this profession. Thank you.
Rakesh, I just wanted to add one small thing. You know, there's a big anomaly here now. If foreign law firms come, thanks to the efforts of people like Dr. Basim, a UK lawyer can come to India and can ultimately, a UK GC, sorry, can come to India, won't be allowed to practice. But if he's there in UK, he can practice in the UK courts. And you're going to have these kind of anomalies which are going to exist. And it is, writing is on the wall. It is going to happen sooner or later. So you are going to have to reconcile not only to the fact that we are wanting a way forward and a statutory recognitions, and recognitions are important. You want to be qualified. You know, it's like saying you want a degree of Harvard to be necessarily called an SJD, which is a recognition of a doctorate, as opposed to just calling it in any other category. Similarly, GC's recognition is one part. But the second, the equality of opportunity amongst different continents, particularly with everybody here practicing with cross-border transactions and other equivalents, you do need to have that in place.
Thank you.
You see, as Mr. Shroff had pointed out, you have a right to practice as GCs. law practice means, as Supreme Court has said in Balaji's case, not just litigation, but all the corporate transactional work. That is law practice. So GCs are already engaged in one part of the law practice, that is documentation, agreements and all that. They don't have to go to external lawyers. So they are already in practice of law so far as corporate and transactional work is concerned. So why there should be any restriction on or prohibition if they have to appear as lawyers in the court or their client? That is what Supreme Court says. Corporate work is a part of law practice. And they are doing, the majority of work is being done by them in-house on the corporate side. Thank you.
Thank you, Dr. Bhasin. Thank you, panelists, for this enlightening discussion. Thank you, audience. I think we have a good takeaway. There are certainly some work to be done, but there is always the opportunity that already exists, as everybody is saying, and we all understand that. I think it is time that everybody recognizes that what are those soft things that needs to change, and that needs to start from the inception, from the law school, from the regulators here, to make it more smoother rather than reading between the lines here. Thank you so much.
Thank you so much, everyone. And now, to present the memento to the panelists, I would like to call upon stage Manjari Chaudhary, founder, GCA Executive Director, and General Counsel, Maruti Suzuki India Limited. I would request the panelists to please take a group photo as well. Thank you so much. We shall now move towards the special addresses by our valuable guests present with us. We are delighted to welcome Honorable Justice Arjun Kumar Sikri, a former judge of the Supreme Court of India. He has been described as evolutionary in his approach to law. His judgments often reflect a forward-thinking perspective, balancing traditional legal principles with contemporary societal needs. His role in recognizing privacy as a fundamental right and decriminalizing consensual homosexual acts showcases his commitment to evolving legal standards to protect individual rights. Justice Sikri is also an experienced mediator and arbitrator, international judge of Singapore International Commercial Court, SICC, and we are eager to listen to his insightful perspectives on the relationship between law and business. Please share your kind words with us, sir.
Thank you very much, and good evening to all of you. I think going by the detailed program which I saw, you have discussed and must have discussed, because I was not privy to it, except the last session for few minutes, which I could witness. All the aspects and all the nuances of today's topic, or the theme of this conference, which has been going on since morning. And what I am going to say may not be new, but it may be summing up of what you might have discussed, number one, or number two, yes, I will be presenting it in my way, which I want to have some discussion, or rather I would say would be sharing my views in this respect. Let me first go back in memory lane about, say, 3 to 4 decades ago, when I was myself a lawyer, and I had more than dozen public sector undertakings, of which I was a legal counsel, apart from private sector as well. So I was remembering one very prominent public sector undertaking. They came to me for retainership and advice, etc. And the person who came was a company secretary. And I was surprised to find out that this company secretary was looking after all the legal matters also of that company. When I asked that you don't have any person, I mean, there may be some position of a law and in the law department, etc. So he said that there is no law department, and we have cases. So the board has asked me to look after those cases, and since now we are, the more and more cases piling up and coming against us, so we thought that we should have some advocate, and it came to. So what I'm trying to say is that surprised to know that there was in a public sector, a big public sector in 80s, there was not even a legal department, what to talk of a person managing the legal department and a company secretary looking after it. And in some other company again at that time, so they came, and it is a private sector company, to me, and again almost same thing, and they said that, look, I was doing their cases, and so some or the other officer to whichsoever department a particular case would belong, so the head of that department, or whether it is a finance or it is marketing or any other, so he would come or she would come and brief me. And when I said that, look, for proper briefing, and you have to give me what is relevant for me, what is not. A person with legal background should be a better person. Then this, after some time, he comes and says that our management has decided, from your juniors, you give us one person who may come to us 2 or 3 times a week, and we'll give him retainer. So this kind of arrangement used to be there in those days when we talk of legal assistance in a company, and how, and the expression general counsel was not even known at that time. So comes 1991-92, which in our history, at least economic history of the country, it's a very, very important period in 91, when under the leadership of Prime Minister Narasimha Rao, with Mr. Manmohan Singh as the finance minister, we ushered into the era of globalization. And this changed the entire ecosystem. Before that, we were a closed economy. And with this now globalization and liberalization, so there was a lot of investment. Earlier, we were an economy which was running on license Raj or quota Raj. All that was liberalized. Most of the important industries or other economic activities were controlled by the public sector. Take, for example, telecommunication, government, no private persons, even insurance, those 4 or 5 government companies, no private persons, electricity, again government, no private players. So, but then it led to privatization and disinvestment of the government in those sectors. Even if you remember ITDC having almost 150, 200 hotels, which again in somewhere in 2001, 2002, when Mr. Arun Shourie was the minister in this Bajpayee government. So except I think Ashoka Hotel and 1 or 2 more hotels, all were given away. Another important thing which happened was that, yes, with the liberalization, that we welcomed foreign investment into Indian sector in a big way. And with this, so many collaborations started, apart from capital investment, but that investment in the technical field, etc., from outside. So collaborations with Indian industry and setting up of many industries, all this started. And this changed the entire ecosystem, not only of economy, but of many, and it had effect or ripple effect on many other activities, and that includes law as well. The many disputes now, if they arose, started becoming cross-border disputes. I remember before 1990, there were hardly disputes which would be, because they were very limited, and that too with controlled methods, foreign investment, so that disputes of that kind would be very, very less. Today, if you see, they are much in number. It's not only arbitration, but in other fields also. I remember having, as a judge of the High Court in the beginning, say till 2005 or 6, heading, and Justice Hima Kohli would have same experience of that time, that on the original side doing the cases, and I'm giving you the example of intellectual property, that most of the cases would be either copyright or trademark. But after 2007-8, if you know, the shift was towards patent matters. This patent, because of the foreign technology coming here and the disputes arising. Of course, it has given impetus to Indian industry also, and if you see now, and the kinds of patent applications which are filed with the patent office, India has also done a wonder. It's not only that we are only, importing capital or importing manpower. It's now other way around also. In in last 30, 40 years, India has also invested in so many other countries, and our entrepreneurs have also gone out. So this changed the complexion of the corporations, corporate sector in this country. And so complex issues which used to be very simple, the issues were more. I remember having done arbitration work as a lawyer till 1999 when I became judge, and I could see or smell some of the changes when, as a judge, when we were doing the arbitration, dealing with those arbitration matters. But after my retirement and in the last 6 years, when I see that the complexion of those arbitration matters has also significantly changed. Now, therefore, in this scenario, when so much of documentation is to be done by a company, when I mean, they have to collaborate with the other companies, etc., and in whatever manner, those aspects are to be looked into. What I told you in 1980s, that a public sector or a private company with no legal department and this can't be imagined today. And another thing which has happened is that with the liberalization, we have drifted away from, as I said, quota and license Raj, privatization, government controls are over, but these are substituted by regulatory mechanism. Today we have regulators in every sector. If it is electricity, yes, there's no control of the government, but there is an electricity regulator which can fix the tariff, etc., which is to be, or can likewise decide the disputes. Telecom, we have again telecom, TRAI and TDSAT. There are, even in banking sector, ombudsmen are there. And another very interesting thing which is happening is that there is a now self-regulatory mechanism also. If you see, and where there is no regulator as such by law, in the example which are given, there are regulators, but then there are in certain sectors there are no regulators. I give you example of this, we call it fantasy sport, or the online sports. You know, Dream 11 and others, when cricket match takes place or the people are playing on that. And then news broadcasters. There is no today for I mean print media. There is a regulator, the Press Council of India. Way back it was I mean created, but for electronic media and news, electronic news, as far as those channels are concerned, there is no government regulation, but there is a self-regulation, and that body is there again, which hears the complaints, etc., and decides those complaints. Now, all this means that, and another, when these regulations come, there are more stricter compliances insofar as companies are concerned. Take the example of SEBI, take the example of, in case of banking, RBI, the way it deals with these cases, and the SEBI regulations, etc. All this calls for a total different approach in which companies have to function today. And it's not only legal matters of the company, but even the policy matters of a company, how the company wants to progress in next 5 years, 10 years, what are the plans, and how they should work, how they should compete with other sector, what could be the legal hurdles in that context, etc. So some legal advice is required. This ecosystem, if I may say so, has made General Counsel today in the entire industry, whichever kind of corporation or company it should be, very, very relevant and very, very important. And so therefore, once we look into this, that this is the role of General Counsel which they have today. And look, when we were just before this session, we were out, standing out, and we were watching many persons who are there, whether it is they are law persons with law background in the publications, legal publications, they are managing that. We have a person like Mr. Tarun Nangia, who is in a general counsel working in this news channel and having those programs. So therefore, there are so many, and I remember many times now when the students or some people come for advice, what should we do as far as law is concerned? So we have to tell them, look, don't see legal profession with a myopic mind, that it is only those in black robes who are in the courts, that is the only legal profession. Today, legal profession is much, much larger than that. There are so many other activities, and once you do law, you can join. It would depend upon you want to be a litigation lawyer, you want to be a corporate lawyer, or you want to be an in-house lawyer or general counsel, and where these kinds of, there are much more avenues which are open. So when we see it from this angle, can we say today that, look, it's only Pinky Anand and the persons belonging to her clan who are practicing the court should be called as lawyers? Answer has to be no. It is not. Lawyers are not only those who are practicing or rather litigating in the courts. Lawyers include all these persons. And if I may quote here Justice Holmes, Justice Oliver Wendell Holmes, was a US Supreme Court judge. What he said, the lawyers of this class have sincere faith in law. They believe law is the business of which my life is devoted, and I should show less than devotion if I did not do what in me lies to improve it. And when I perceive what seems to me the ideal of its future, if I hesitated to point it out and to press towards it with all my heart. So when he says this clause, he was, because it's statement given more than 100 years ago, was thinking of that clause in those times as if the whole class is those who are practicing. But that is not what the position is as of today. And when we talk of class, it is, as I said, that all these classes. So in most of us, as I said, that law brings forth images of people standing on their guard, dictating right and wrong, stiff, perhaps a little harsh. In reality, law is nothing like it. Law is the ability to bring a balance in all things. It is what keeps all of us tied with strings of justice. The lady holds the scale of justice, weighing the situations till they are balanced. She is blindfolded, but not any longer in India, and particularly in our Supreme Court, because our previous Chief Justice had removed that fold from her eyes. So it is the ability to weigh facts, pros and cons in an objective manner. Law have been made by humans for humans. They are the rules which govern and influence society and ensure that humans learn to accept the ways of each other in a harmonious way. And keeping in mind this aspect, therefore, law is all encompassing, and whosoever are the players who are bringing this balance would be lawyers. And so in-house lawyers today are even looking after the regulatory measures which are to be followed. I have seen in many, I'm not very sure whether you are holding the position of a director in your company. Yeah, okay. The many I've seen who are even they have made it to the board of directors. So they are even contributing to the policy making, because it is not possible to work without a counsel in the company, general counsel, that the board decides or takes any decision without their legal assistance which is required. And it is for this reason what you have been discussing since morning, that the recognition to the general counsel as a part of legal community becomes very important and justified as well. If I say so from constitutional point of view, we have said that the dignity of a person is a facet of Article 21. And there are so many judgments on that. And identity of a person in transgender judgment, that identity which was given to them. But of course, not strictly in that sense, but identity which is required to be given to general counsel, keeping in view their dignity, I would say at constitutional level also demands that you become part of legal profession and are recognized as such. See it from another angle, that the domain practice, some of the practices, for example, appearing before income tax officer, CIT, Commissioner of Income Tax in Appeals, or even Income Tax Appellate Tribunal. Chartered accountants, they are not lawyers. These are quasi-judicial bodies, they are allowed. In this IBC, that NCLT, that Insolvency and Bankruptcy Code, NCLT and NCLAT and CLAT, chartered accountants, cost account, not only allowed, they are made members of NCLT also, performing their judicial duties. So normally a judge in the court is only person that would become who is in practice. So he or she will become, but in NCLT, NCLAT and even in ITAT, the people are chosen from their respective domains. So when it is extended there, and one thing more which I saw was that in US, UK, Australia, Canada, Singapore, Hong Kong, general counsels are recognized, they are embraced into the legal profession and recognized as such. Of course, except Singapore and Hong Kong, others are Western countries. But see the legal profession, how it is mushrooming, and how it has made mark in Singapore and Hong Kong. Hong Kong much earlier, it's little waning because of various other reasons. We need not go into that. But Singapore, it is only because of their much wider perception about the legal profession and how GC should also be recognized. That makes a difference. And when that is there, and we have one thing more, I must say, you people may not even be knowing, and I think Justice Hima Kohli would be knowing. She knows those two persons I am going to give the example of. That normally judges, as I said, are made, are elevated from legal profession. When it comes to the judiciary at lower level, that is district court level, we need, the prescription is 7 years or 10 years practice. In Delhi, we had made, and I was part of those decisions at that time, one professor working in, professor of law working in Delhi University as the judge, additional district judge. We had made one, again, law officer or general counsel working in a public sector undertaking as a judge, saying that no, you also qualify for certain reasons. So if a professor in a university, a general counsel in a public sector can qualify the description of 7 or 10 years practice which is needed, then why not general counsel be treated as lawyers? That is another very, very important factor which go in this way. So with this, I will only say, will not take much more time, that my good wishes to all of you, and I hope that day is not far away when you get your identity with dignity and due recognition which is due to you. Thank you very much.
Thank you so much, sir. To give away the memento, I would call upon Shukla Vasan, founder, GCAI, independent director, legal, corporate consultant, conflict resolution, arbitration, mediation, former General Counsel, Hindustan Coca-Cola Beverages Private Limited. Thank you, sir. So as we know, our chief guest is on his way, so we'll just wait for a few moments as he arrives. Meanwhile, I would just like to bring to your notice again, excuse me. Nice. I would request everyone to please settle down. Everyone, I would request you to please settle down as we continue with the program. With that, I would like to welcome our chief guest of this evening, Shri Arjun Ram Meghwal, a three-time member of parliament and former IAS officer. He currently serves as India's Honorable Minister of Law and Justice. Shri Meghwal has focused on implementing judicial reforms to reduce the pendency of cases and improve the overall efficiency of the judiciary. He has emphasized the importance of constitutional values and awareness. Under his leadership, the Law Ministry has worked on various legislative initiatives to update and modernize existing laws, ensuring they are in line with contemporary needs and global standards. Shri Meghwal has prioritized improving access to justice for all citizens, particularly marginalized communities. This includes initiatives to strengthen legal aid services and promote alternative dispute resolution mechanisms. He has been a strong advocate for the digital transformation of the legal system, promoting the use of e-courts and other digital tools to make legal processes more efficient and accessible. We look forward to hearing his views on India's aspirations and the expectations from the legal profession in this journey. Please share a few words with us, sir.
ये हमारे लिए बड़े सौभाग्य की बात है कि आज मेघवाल साहब हमारे बीच में हैं। पिछले कुछ वर्षों में जिस तरीके के लीगल रिफॉर्म्स हिंदुस्तान में हुए हैं, उसमें मेघवाल साहब का कंट्रीब्यूशन बहुत सिग्निफिकेंट रहा है। चाहे ईज़ ऑफ डूइंग बिजनेस से रिलेटेड रिफॉर्म्स हो या रिडक्शन ऑफ केसेस के मामले में रिफॉर्म्स हो, उन सभी में बहुत बेहतरीन कंट्रीब्यूशन रहा है। और हमारी दरख्वास्त आज ये भी है, जो हमारी लीगल फ्रेटर्निटी यहाँ बैठी है, जो इन हाउस काउंसिल्स हैं, जनरल काउंसिल्स हैं, मेघवाल साहब उस रिफॉर्म्स के बारे में भी सोचेंगे और हमको उसके मामले में आशीर्वाद देंगे। मैम आप एक बार चलते हैं, आई थिंक दैट वुड बी या may I now invite Justice Kohli for her views in terms of the kind of legal reforms which India needs in terms of the global economy, in terms of the economic growth which we are seeing, or the economic growth which our India Vision 2047 envisages, which is $30 trillion economy. Thank you very much.
Very good evening to all of you. Mr. Meghwal, Honorable Minister of Law and Justice, Government of India, distinguished guests on the dais and off the dais, the panelists, founder members of GCAI and members of GCAI, friends from the media, ladies and gentlemen. I'm delighted to be present for the concluding session of a day-long conference on navigating change, perspectives from legal ecosystems that has been organized by GCAI, a wonderful initiative. Today's theme necessitates a deep reflection on how our legal profession must adapt and evolve to meet the emerging challenges and opportunities of our times. India is undergoing a remarkable transformation characterized by rapid economic growth and significant societal changes. According to the Economic Survey of 23-24 released by the Ministry of Finance in July of 24, India's GDP growth from $288 billion in 1993 has jumped to $3.6 trillion in 2023. Currently, India ranks 5th in the world's GDP ranking by IMF, and as per the Economic Survey of 24-25 presented in the Parliament this morning by the Finance Minister, the Indian economy is projected to be expanding at a rate of 6.3 to 6.8% in the financial year 25-26. This growth trajectory is particularly noteworthy as India has generated a more growth per dollar of debt than comparable nations. Even more significant is India's resilience. Despite the pandemic-induced economic shutdown, the nation has demonstrated swift recovery, powered by robust private consumption and strategic government focus on infrastructure investment. This remarkable growth is fueled by a diverse economy that thrives on key sectors such as information technologies, services, agriculture, manufacturing. With a youthful and technologically adept labor force and an expanding middle class driving consumption, India's economic landscape is rapidly evolving. According to World Bank's flagship report, the Global Economic Prospects that was released in January of 25 this month itself, India, along with China and Brazil, has been instrumental in driving the emerging market and the developing economies. A remarkable growth which now commands 45% of the global GDP, up from 25% in the year 2000. The report also indicates that India is projected to remain the world's fastest growing major economy with 6.5% growth in 24-25. This economic ascendancy brings with it unique challenges and opportunities that are reshaping our legal landscape. As corporate transactions become increasingly complex and demands of international trade evolve, our legal profession must adapt to these changes. So let's look at legal practice and diversity. The evolution of legal practice in India is a remarkable story of adaptation and transformation. From ancient times, when our legal principles were deeply rooted in religious texts and community values, through the medieval period, blends of traditional jurisprudence to the modern era of formal structure, our legal ecosystem has continuously evolved while preserving its cultural roots. The current legal landscape in India is a tapestry woven from diverse threads of our national identity, where multiple systems coexist and evolve, from constitutional courts to specialized tribunals, from commercial courts to consumer fora, from arbitration centers to traditional panchayats, institutional mechanisms to lok adalats. Our legal ecosystem spans corporate boardrooms to rural grassroots, serving diverse demographies and catering to manifold legal needs. This diversity has profoundly influenced both legal interpretation and judicial justice system. As India's socio-economic landscape transforms from rapid urbanization to digital revolution, changing the social structures and evolving commercial relationships, our legal profession adapts its practices and principles while balancing regional nuances with international standards. This evolution presents opportunities and challenges demanding continuous adaptation to ensure our legal ecosystem remains responsive to our nation's diverse needs. Now let's examine what has been the shift towards ADR, something that Justice Sikri also touched upon in his speech just a few minutes ago. One significant manifestation of this evolution is the paradigm shift towards ADR. ADR isn't just an alternative anymore. It's becoming the preferred first step in dispute resolution, offering modern businesses what modern businesses and clients desperately need. And what is their need? Speed, cost effectiveness, confidentiality. The traditional perception of lawyers as courtroom warriors has changed. Today's legal landscape demands professionals who are skilled in negotiation, in mediation, and arbitration, mastering not just the law, but the delicate art of conflict resolution. A watershed moment in the Indian legal landscape has been the Mediation Act of 2023. This piece of legislation is not merely an act, but an testament of our collective yearning for a more efficient, harmonious, and less adversarial method of dispute resolution. While no single approach can be a panacea for all legal challenges, this act is indeed a promising addition to our toolkit, for it encourages dialogue over discord, resolution over litigation, and an endeavor to forge harmonious relationships over aggravated, prolonged hostility. India's evolving role in the realms of arbitration and mediation is not merely a professional endeavor, but a collective journey towards creating a world where justice is more readily accessible, more aligned with the rapid pace of globalization, and more reflective of our shared digital reality. This shift towards ADR aligns with global best practices and resonates with the inherent values of our legal framework, advocating for resolutions that uphold the dignity and respect of all the parties concerned. There is something that we need to talk about when it comes to expertise and regulation. While ADR represents one transformative change in our profession, another equally significant shift is now occurring in how legal expertise has developed and is being deployed. The contemporary legal landscape reflects significant regulatory transformations through amendments made by the legislature to several enactments, from insolvency resolution through IBC, to real estate regulation through RERA, banking sector reforms through SARFAESI, and amendments to the implementation of the GST. Our legal ecosystem must now navigate opportunities presented by simplified regulatory frameworks, technology-driven governance, and international best practices, while addressing challenges of evolving business structures and digital transformation. The future of legal practice lies in industry-specific expertise. Today's legal challenges require deep specialized knowledge, whether it is in fintech regulation, pharmaceutical patents, or renewable energy contracts. Clients expect the legal profession to intimately understand not just the law, but their business environment. Recognizing these evolving demands, legal education in India is being transformed with the inclusion of emerging tools of technology like blockchain, AI, and cybersecurity. This trend towards specialization is just not creating new opportunities, but also demanding continuous learning and adaptation. The 2023 BCI rules for registration of foreign lawyers and the subsequent Memorandum of Understanding signed in June of 23 between the Bar Council of India and the legal bodies of England and Wales illustrates this evolution, enabling knowledge exchange through short-term placements in international commercial arbitration and non-litigious matters. This demonstrates how cross-jurisdictional exposure can enhance legal expertise while maintaining regulatory safeguards. As these transformations have unfolded, the scope of legal practice has expanded far beyond traditional courtroom advocacy. Today's lawyers must navigate increasingly diverse areas, whether from environmental law or to intellectual property, from consumer protection to cyber law. As new categories of legal rights emerge, the profession demands multidisciplinary expertise. Litigation practitioners must be conversant with subjects as varied as architecture and theatre, shipbuilding and sound recording, nanoscience and genome sequencing. This convergence of law with multiple disciplines, coupled with emerging market demands, requires legal professionals to develop not just legal acumen, but a comprehensive understanding of various fields while aligning domestic practices with global standards. What is the role that technology has played in this transformation? Another, and perhaps a prominent transformative element, is the technological revolution in legal services. The IMF's June 24 report warns of profound labor disruptions from generative AI. For the legal profession, this isn't just about automation. It's about re-imaging practice, from predictive analytics in litigation to automated contract reviews. AI tools are becoming indispensable. The challenge lies in harnessing these tools while maintaining the element of human decision and ethical oversight that are the hallmarks of a professional. This technological transformation extends beyond AI, the rise of the virtual ecosystem in democratizing legal practice. Virtual courtrooms, digital consultations, and remote collaboration aren't just adaptations of the pandemic era. They are the new normal. This radical shift has created unprecedented flexibility in how legal services are delivered and consumed. Lawyers can now build global practices from anywhere in India, while clients can access specialized legal expertise without facing geographical constraints. No doubt, AI tools are revolutionizing legal practice, but they must complement, and I repeat, complement and not replace the human element and the decision making. The role of legal professionals remains paramount, for it brings in empathy, contextual understanding, and nuanced reasoning that no algorithm can replicate. AI should therefore not be viewed as a threat, but as an opportunity to enhance the quality of legal practice, automating routine tasks, improving research efficiency, and providing data-driven insights. This integration presents significant challenges. We must address critical ethical concerns, though, from algorithmic bias to data privacy, from transparency in decision-making to maintaining human oversight. The digital divide risks creating new barriers for those who cannot afford technology-enabled services is also an aspect. Our approach must ensure that technological advancement enhances rather than compromises access to justice and the fundamental principles of our legal system. Coming to corporate legal practice, The landscape of legal practice is undergoing a profound transformation, a sea change driven by complex corporate transactions, international trade demands, and evolving global economic dynamics. In this background, the general councils have emerged as critical business enablers, bringing strategic vision with legal expertise. This role demands an unprecedented interdisciplinary approach, requiring professionals to balance sophisticated corporate interests with broader societal responsibilities. However, our regulatory framework, particularly the Advocates Act and the Bar Council regulations, has yet to fully recognize the nuanced strategic roles played by modern legal practitioners as in general counsel. To my mind, they must be mainstreamed and rub shoulders with litigation practitioners as co-equals. As our corporations increasingly operate on global stages, our legal professionals must navigate intricate regulatory frameworks, serve diverse stakeholders, and simultaneously maintain the delicate equilibrium between profitability and public service. The future of legal practice is no longer in traditional boundaries, but in creating adaptive, knowledge-driven frameworks that can respond to complex demands of a rapidly changing economic landscape. To conclude, at this pivotal juncture of transformation, one can safely state that legal profession's evolution hinges not merely on adaptive capabilities, but on a proactive role in shaping the change. Our legal ecosystem represents a confluence of diverse legal traditions, modern corporate practices, and emerging dispute resolution mechanisms, where interconnected nature of practice necessitates seamless collaboration across all spectrums of stakeholders. The trajectory of India's legal profession rests on our capacity to embrace the change while preserving core values, fostering innovation with honoring tradition, and maintaining global perspectives while ensuring local relevance. This transformation demands a paradigm shift from being perceived as a procedural impediment to becoming a catalyst for economic growth and societal progress. Through synchronized efforts, commitment to continuous learning, and unwavering pursuit of excellence, India's legal ecosystem is well positioned to emerge as more robust, more inclusive, and better equipped to serve our nation's diverse needs. To my mind, that is what navigating change, the subject of today's discussion, is all about. Rethink, redefine, and re-evolve. Thank you for your attention.
Thank you so much, ma'am, for that wonderful speech. And we would now move forward to the address by our chief guest, Sri Arjun Ram Meghwal, Honorable Minister of Law and Justice, Government of India.
सब्जेक्ट तो खैर बहुत अच्छा रखा है आपने, यहीं से शुरू करते हैं। रीथिंक, हमें भी रीथिंक करना है क्या? रीडिफाइन एंड री-इवॉल्व द लीगल प्रोफेशन इन इंडिया, यही है ना सब्जेक्ट? तो बहुत अच्छा सब्जेक्ट। और इस अवसर पर उपस्थित ऑनरेबल जस्टिस हीमा कोहली जी, हमारे सीवी रघु जी, GCAI के फाउंडर मेंबर डॉक्टर पी आनंद जी, सीनियर एडवोकेट सुप्रीम कोर्ट ऑफ इंडिया डॉक्टर संजीव गेमावत जी, और निखिल प्रसाद जी, और शुक्ला वासन जी, सभी से जुड़े हुए लोग। मेरे ख्याल में आपका दिन भर से चल रहा था क्या कार्यक्रम? चलो मैं आपको एक एक्सरसाइज कराता हूँ। वो आप उसी में ही सारी चीज़ें आ जाएगी। मुझे अब भाषण देंगे तो आपको भाषण तो सुबह से ही सुन रहे हैं ना। मैं अभी बैठा बैठा संजीव जी से बात कर रहा था तो मेरे समझ में आया कि एक तो बीसीआई कहता है कि आप एडवोकेट नहीं हो, यही है ना एक प्रॉब्लम, या और कोई प्रॉब्लम है? ये बड़ी प्रॉब्लम है ना। तो इसको हल करने के लिए मैं बैठे बैठे सोच रहा था कि एक आपसे एक एक्सरसाइज कराएं। तो आप ऐसा कमज़ोर अपना आप को मत समझो, और क्योंकि मैं यहाँ आया हूँ तो कुछ ना कुछ इसकी एक्सरसाइज, एक मैनेजमेंट में जब हम पढ़ते थे तो एक एक्सरसाइज होती थी जिसको हम शॉर्ट एनालिसिस कहते हैं। तो आपके ऑर्गेनाइजेशन की, या आप जो लीगल प्रोफेशन में हो, जनरल काउंसिल जिनको हम बोलते हैं, इनकी स्ट्रेंथ क्या है? कोई 1 2 3 बताएंगे क्या स्ट्रेंथ है? आप यूनाइट हो या नहीं हो? यूनाइट है तो ये भी आपकी स्ट्रेंथ हो गई ना। हाँ, नहीं ज़्यादा कह रहे हैं, 2 लाख से 5 लाख कह रहे हैं। तो आपकी, पहले मैं आपको पूछ रहा हूँ कि आपकी स्ट्रेंथ क्या है? शॉर्ट एनालिसिस में 4 शब्द है स्ट्रेंथ। तो आपकी ताकत क्या है? स्ट्रेंथ। आपकी स्ट्रेंथ से मतलब नंबर से नहीं, आप जैसे यूनाइट हो, आप प्रोफेशनल कॉम्पिटेंसी रखते हो, ये आपकी स्ट्रेंथ हो गई ना। ऐसे आप 8 10 बताएंगे क्या? बड़ी बड़ी कंपनी में हो, ये भी आपकी स्ट्रेंथ है। जैसे किसी ने कहा मारुति में है, किसी ने कहा विप्रो में है, तो ये छोटी ताकत थोड़ी है, बड़ी ताकत है आपके पास। तो ये ऐसी स्ट्रेंथ कोई बताएंगे 1 2 3 4? कॉरपोरेट गवर्नेंस आपके कारण ही होता है, ये भी ठीक है। मतलब नॉर्मल एडवोकेट इसको नहीं कर पाएगा ना। गवर्नमेंट कंप्लाइंसेज, रेगुलेटरी कंप्लाइंसेज, जैसे कौन कौन से? आप सारे यही करते हो क्या? जीएसटी, आईटी, टैक्स लॉ, सीसीआई, मुझे किसी ने बताया सीसीआई सब कुछ, सेबी लॉज, माइनिंग लॉज, आरबीआई। आरबीआई का क्या है? फेमा, फेमा, सेबी, इन्वायरमेंट, लेबर कोर्ट में भी, लेबर लॉज, कंप्लाइंसेज, कंपनी के पॉलिसी मेकर है। ये बड़ी बात बताइए। और पॉलिसी में भी लीगल पॉलिसी के आप अच्छे जानकार हो। अच्छा, किसी को और याद आ जाओ तो बता देना। ताकत में पूछ रहा हूँ, स्ट्रेंथ। अब आप वीकनेस बताएंगे क्या है आपके इस पूरे जो आपके जनरल काउंसिल्स का विषय है, उसमें जो अभी बैठे बैठे मेरे समझ में आया, एक वीकनेस तो आपकी बीसीआई से विषय है। वीकनेस बताएंगे क्या? 3 4 5 है? वकील होते हुए भी कोर्ट में नहीं जा सकते। नहीं नहीं नहीं, 1 मिनट, ये कह रहे हैं ना कोर्ट में नहीं जा सकते, ये एक वीकनेस है। नहीं, उसको आगे लेना। वीकनेस क्या है? नहीं, अपॉर्चुनिटी आगे लेंगे, पहले वीकनेस पूछ। ये समस्या होती है इसमें, क्या वीकनेस में थोड़ी कम आती है। याद आओ तो बताना। नहीं, आप ऐसे यूनाइट तो ऑर्गेनाइजेशन बना हुआ है क्या? जैसे बार काउंसिल बने हुए हैं, ऐसे आपका कुछ है क्या? ये कब बनाया है? हाँ, तो इसका मतलब ये थोड़ा आपका नया है। इसको तो इसको टीचिंग ट्रबल में डाल दें क्या? उसको और कोई बताएगा इसको वीकनेस क्या है? आपके पूरे प्रोफेशन की वीकनेस क्या मानते हो आप? आपकी स्ट्रेंथ तो अच्छी आई है, मुझे लगा कि स्ट्रेंथ में तो आप आगे हो। हाँ, एक विषय आया कि हमें एडवोकेट कहते नहीं लोग। नहीं, मुझे अभी ये कह रहे थे संजीव जी की घरवाली भी कहती है वकील नहीं हो आप। ये भी एक विषय है इन्होंने कहा, वो कह रहे थे कि वो भी कह रही है वकील नहीं हो आप। कहाँ है, कहाँ सुन रहे, बैठे हैं क्या संजीव जी का मिसेज? कौन है? क्या नाम है? अगर सुन रहे हैं तो पूछ लेता हूँ मैं। कनीता जी, कनीता जी सुन रहे हो तो बाद में बता देना वीकनेस। इसका मतलब आपको लीगल प्रोफेशन में होते हुए भी वकील नहीं माना जाना, ये एक इस ऑर्गेनाइजेशन की, आपका ने जो ऑर्गेनाइजेशन बनाया उसकी ये वीकनेस है। क्यों आप ऐसा मानते हो? और क्या वीकनेस है?
एक ही वीकनेस सर मुझे लगती है कि इतनी सब स्ट्रेंथ होने के बावजूद भी हम उस स्ट्रेंथ को अभी तक प्रोजेक्ट नहीं कर पाए, हम कम्युनिकेट नहीं कर पाए। और शायद वो कम्युनिकेशन,
ये आप लोग आर्बिट्रेशन में, उसमें मीडिएशन काउंसिल में काम नहीं करते हो क्या?
नहीं, हमें सर आर्बिट्रेशन और मीडिएशन हमारे कारण ही चलता है, लेकिन आर्बिट्रेटर और मीडिएटर कोई और होता है।
अच्छा, चलता आपके कारण है?
हाँ, चलता हमारे कारण है।
बिजनेस हम लेके जाते। तो आपका ये कह सकते हैं कि एक ये वीकनेस है सिस्टम में, एक आपका इनडायरेक्ट कुछ इन्वॉल्वमेंट रहता है, डायरेक्ट नहीं रहता, ऐसा कह सकते हैं?
मैं ऐसा भी नहीं कहूंगा सर, क्योंकि जो कंटेंट है, जो लॉयर आर्ग्यू
नहीं, आप क्या कहोगे? क्योंकि हमें ये स्टडी आज आपके लेके जानी है मेरे दफ्तर में।
जी सर।
मुझे वहाँ हमारे दफ्तर में जो सेक्रेटरी, एडिशनल सेक्रेटरी, जॉइंट सेक्रेटरी, उनको यही करवानी है मुझे।
जी सर। जी।
जो बहस आप भी कर सकते हो लेकिन आप नहीं कर पाते हो, आपको अपॉर्चुनिटी नहीं मिलती क्या? ये वीकनेस है, मैं भी मानता हूं, मैंने कहा है ये। अभी जैसे यूनाइट होंगे आप अच्छी तरह से, तो ये चीजें, जैसे हमें बुलाया, हिमा जी को बुलाया, बोली नहीं, मैं ये भाषण नहीं दूंगा, मैं ऐसे ही आपको इन्वॉल्व करूंगा। आपको ठीक लग रहा है क्या मेरा पढ़ाने का तरीका? आप बताइए, आप क्या कहना चाह रहे हैं, आप बताइए।
इंडस्ट्रीज में देखें, वहाँ वर्कर्स की ट्रेड यूनियन होती है और ट्रेड यूनियन की लॉ, तो ट्रेड यूनियन की रिकॉग्निशन होती है। अगर हमें भी कुछ लॉ की थोड़ी सी सहूलियत मिल जाए जहाँ पर हम भी अपनी यूनियन बनाए और हमारी भी रिकॉग्निशन जनरल काउंसिल एसोसिएशन करके हो जाए, जिसको रिकॉग्नाइज करें स्टैट्यूटरी, या तो हमारी इस एसोसिएशन को रिकॉग्नाइज करें या हम स्पॉट बड़े पैमाने पर ले जाए, धीरे धीरे सब जुड़ने लगे उससे, तो एक हमारा ऑल ओवर इंडिया एक यूनियन बन के आए।
तो आप यही कह दो ना, बीसीआई से जुड़ जाए तो ज्यादा ठीक है, वो ज्यादा ठीक है। अब वो वीकनेस का ही पार्ट है ना, तो अब आपके पास अपॉर्चुनिटी क्या है? नहीं, जैसे एक अपॉर्चुनिटी तो हमने हिमा जी से सुनी कि हम 5th लार्जेस्ट इकोनॉमी हैं और 3rd लार्जेस्ट इकोनॉमी बनेंगे, तो उसमें आपका योगदान नहीं हो सकता क्या? तो ये आपके पास अपॉर्चुनिटी है ना, का नहीं है? ऐसी आप बताइए 3-4 अपॉर्चुनिटी। सब्जेक्ट मैटर रेस्पेक्ट, बिल्कुल ठीक है। कोई अगर हमें सेबी का अच्छी तरह से पैरवी करानी, तो हमें ढूंढना पड़ता है यार सेबी का कौन जानकार है, फिर उसको कहते हैं वो ठीक है, कोई कहता है वो ठीक है। तो आप तो इसी काम को करते हो, लेकिन आप अपीयर नहीं हो सकते। मैंने आपको पहले पूछा था आपको कि भी ये आर्बिट्रेशन और मीडिएशन, ये एक ऐसा एरिया आ रहा है, ये एडीआर का पार्ट है, लेकिन ये जल्दी तेजी से भारत में बढ़ेगा, तो इसमें आप लोगों की मुझे लगता है जरूरत पड़ेगी, ऐसा मैं समझता हूँ। तो ये अपॉर्चुनिटी का विषय हो सकता है। फिर भी आपकी अपॉर्चुनिटी तो है ही, अपॉर्चुनिटी है। हमें प्रधानमंत्री जी ये कहते हैं कि हमें भारत को आर्बिट्रेशन का हब बनाना है। अब उन्होंने एक लाइन दे दी। अब वो आर्बिट्रेशन का हब कैसे बनेगा, वो हम लोग सोचेंगे, आपसे कंसल्ट करके, कोई और एक्सपर्ट है उनसे कंसल्ट करके, कभी सी इंस्टीट्यूट में जाएंगे तो उनसे कंसल्ट करेंगे, कभी CS इंस्टीट्यूट में जाएंगे तो उनसे कंसल्ट करेंगे, कभी CMA इंस्टीट्यूट में जाएंगे तो उनसे तो कैसे अब बनेगा। मैं यही अभी लंदन में गया तो एक प्रोग्राम में तो हिमा जी हमारे साथ थे एक प्रोग्राम में, अभी एक दूसरे प्रोग्राम में मैं गया तो प्लेन में हमें एक बात करने लग गया कोई आदमी, तो उसने कहा साहब मैं आर्बिट्रेशन के लिए जा रहा हूँ। तो मैंने पूछा भी आर्बिट्रेशन में किसका कर रहे हैं, तो साहब पार्टियां तो दोनों इंडिया की है, वो आर्बिट्रेशन जो वहाँ लंदन में तय हुआ है वो जज भी इंडिया से ही संबंध रखता है, और मैं वकील हूं, मैं भी भारत से ही संबंध रखता हूं। अब बताइए, पार्टियां भी भारत की, जज भी भारत का, और आर्बिट्रेशन लंदन में हो रहा है। हाँ, यहाँ क्यों नहीं हो रहा सर? हो सकता। ये अपॉर्चुनिटी हमें लेनी है। तो अगर हमारे पास एक्सपर्ट नहीं है तो आपके इस लॉट से हमें एक्सपर्ट मिल जाएंगे कि नहीं मिलेंगे? तो ये भी हमारे पास अपॉर्चुनिटी है। अब थ्रेट क्या है आपका? क्या चुनौती है आपको जिस कारण से आप आगे नहीं बढ़ पा रहे हो इस मामले में? बीसीआई है? बीसीआई को है या उनके जो जुड़े हुए वकील है उनको है थ्रेट? बीसीआई तो एक स्टैट्यूटरी बॉडी है भाई, लेकिन उससे जुड़े हुए वकील सोच रहे होंगे हमारी दुकान बंद हो जाएगी, ऐसा सोच रहे हैं क्या? तो क्या है थ्रेट? दिक्कत क्या है? कुछ आप चुनौती बताएंगे तो फिर मैं बीसीआई से बात करूंगा ना। मनन मिश्रा जी आजकल हमारे राज्यसभा में आ गए हैं ना, चेयरमैन। क्या है मतलब आपको क्यों नहीं वो, और कौन कौन से देश में ये जो उनकी वकीलों की जो काउंसिल है उससे ये जुड़े हुए हैं इस तरह से, जनरल काउंसिल वाले? यूएस, तो हमारे पास उदाहरण तो खूब है? और वहाँ सीधे मेंबर बन जाते हैं या और कोई कंडीशन डालते हैं? कोई उनका जो वहाँ यूएस या किसी का भी बहुत अच्छा किसी का हो तो एक पेज का हमें इसको लिख के देना, क्योंकि आज जो मुझे बुलाया, मुझे लगता है आपने अपॉर्चुनिटी के अवसर पर ही बुलाया मुझे। 1961 एडवोकेट एक्ट अमेंड हो रहा है। आपने ताली पहले ही बजा दी, इन्होंने पहले ही बजा दी है? नहीं, उम्मीद पे दुनिया कायम होनी भी चाहिए। और फिर आप कोई गलत बात, मुझे नहीं लगता कि कोई गलत बात कह रहे हो, तर्कपूर्ण अपनी बात कह रहे हो कि भाई हम लीगल प्रोफेशन के लोग हैं, हमने भी एलएलबी किया है, हमने 3 साल का डिग्री कोर्स भी किया है। अभी बता रहे थे संजीव कि 5 साल के वो लोग भी हैं, एनएलयू से किए हुए लोग भी हैं, लेकिन वो ठीक है वकील नहीं बनना चाहते, वो इसमें आ गए। और अब हमें अगर बीसीआई रिकॉग्नाइज नहीं करती है तो हमारा जो एक्सपीरियंस है वो काउंट नहीं होता है कि हम कितने साल की हमारी प्रैक्टिस है। तो जब काउंट नहीं होता है तो सीनियरिटी वकील की वो भी नहीं मिलती। आपको अपनी कंपनी में प्रमोशन मिलता होगा वो अलग विषय है, लेकिन वकील की भी सीनियरिटी आपको मिलनी चाहिए, या उसकी गणना भी नहीं होती। ये कह रहे हैं गणना ही नहीं हमारे पास, तो ये कह रहे हैं है बीसीआई को, तब जाकर के आप, तो वो क्या ऐसा मानते हैं कि भाई आपको परमानेंट इनकम है, हम तो लड़ रहे हैं। जैसे मैं अभी बीजेपी का लीगल सेल का एक प्रोग्राम था, हमारे पार्टी कार्यालय में गया, तो एक वकील साहब ऐसा सुना रहे थे कि एक दिन मैं लोगों का केस देख रहा था तो कोई भी पैसा मुझे वो फीस नहीं मिली। वो पुरानी बात बता रहे थे। तो बोला एक बार कोई आदमी आया तो उसने कहा मेरा ये वारंट है ऐसा, तो उसमें उसने मुझे 30 रुपए की फीस दी। तो कभी कभी बोला हम वकीलों को इनकम ही नहीं होती, वो अपनी बात बता रहे थे। आप के लिए वो ऐसा बीसीआई सोचते होंगे भी आपने तो एक परमानेंट इनकम वाला एरिया चुना, ऐसा सोचते होंगे, क्या है उनका ऐसा? आपको विरोध क्यों करते हैं, मेरी समझ में आया नहीं अभी तक। अच्छा, कॉन्फ्लिक्ट ऑफ इंटरेस्ट से लिया क्या? ऑफिस ऑफ प्रॉफिट एक्ट आ रहा है क्या? तो मुझे तो ऐसा लगता है इस शॉर्ट एनालिसिस से कि चुनौती कोई बड़ी नहीं नजर आती मुझे, ठीक है। स्ट्रेंथ अपने पास काफी है। अगर स्ट्रेंथ और बढ़ानी है अपने को, 1 2 3 4 जो ताकत है और बढ़ानी, वीकनेस है भी कम है तो उसको कम करनी है, और अधिकतर आपने एक ही बोली है, और मुझे लगता है कि मैं उसको कम करने की स्थिति में हूं। ठीक है, जो आपने वीकनेस बोली है इसको हम कम करने की स्थिति में हैं, मैं चर्चा करूंगा। आज हमारे लॉ सेक्रेटरी भी यहाँ दिन में आए थे शायद, मैंने आने से पहले उनसे बात की, भाई क्या है विषय। और अब जब हर चीज का एक लिबरलाइजेशन का जमाना है, सब चीजें खुल गई, हम इसमें इस बर्डन में क्यों हैं कि भाई इनको हम नहीं मानेंगे एडवोकेट, ऐसा क्यों, और इससे हमें फायदा क्या सरकार को, ये मैंने पूछा है उनसे। हम अगर इनको नहीं मानेंगे एडवोकेट तो हमें सरकार को बेनिफिट क्या है ये बताओ, मुझे समझाओ, और अगर हम मान लें एडवोकेट नुकसान क्या है ये बताओ। तो जवाब नहीं दे पाए, तो जवाब नहीं दे पाए इसका मतलब काम होने की ओर बढ़ रहा है, आप समझ रहे हैं? काम होने की ओर बढ़ रहा है। अच्छा, मुझे लगता है कि आपका ये आज का सम्मेलन है और जरूर कुछ न कुछ 2025 में पहुंच गए। जनवरी आज समाप्त हो रहा है, कल बजट आ रहा है, बजट में चीजें अच्छी आएगी, लेकिन जीडीपी को टच किया है हिमा कॉलेज ने, तो उसको मैं थोड़ा सा आपको ब्रीफ करके मेरी बात को समाप्त करूंगा। जीडीपी हम बढ़ाना भी चाहते हैं, कोई भी देश हो जो विकसित होना चाहता है वो जीडीपी बढ़ाना चाहता है, और जीडीपी में को जीडीपी का जो बास्केट है उसमें 3 कंपोनेंट रहते हैं। पहला कंपोनेंट है कंजम्पशन का, और दूसरा कंपोनेंट है इन्वेस्टमेंट का, और तीसरा कंपोनेंट है एक्सपोर्ट का। सबसे बड़ा कंपोनेंट ये कंजम्पशन का रहता है, जो 62% से लेकर के 68% तक वेरी करता है, और जो इन्वेस्टमेंट का जो कंपोनेंट है वो 25% से लेकर के 28% तक वेरी करता है, और एक्सपोर्ट का जो कंपोनेंट है वो 3 से 5% के बीच में वेरी करता है। लेकिन ये तीनों स्ट्रॉन्ग अगर पिलर हो तो हमारी जीडीपी बढ़ती ही जाएगी, कम नहीं हो सकती। अब ये स्ट्रॉन्ग पिलर पे हमारी जीडीपी खड़ी है। आईएमएफ का जिक्र किया जस्टिस हिमा कोहली जी ने, वो कोई हमारी संस्था नहीं है, लेकिन हमारा जो ये जीडीपी का जो आंकड़ा है और जीडीपी की जो गणना होती है उसमें कंजम्पशन लेवल हमारा आगे 8-10 सालों में भी ठीक रहेगा। कंजम्पशन को आप भी बढ़ा रहे हो, कम नहीं होने दे रहे हो। आपने जूते खरीदे होंगे, काला कोट आपने भी खरीदा होगा, चश्मा भी खरीदा होगा, आप कुछ और भी शादी में भी खर्च कर रहे होंगे, लेकिन कंजम्पशन आप कम नहीं होने दे रहे हो, कंजम्पशन को आप भी बढ़ा रहे हो, लेवल भी रख रहे हो। और इन्वेस्टमेंट 2 तरह का होता है, एक पब्लिक इन्वेस्टमेंट है, एक प्राइवेट इन्वेस्टमेंट है। तो पब्लिक इन्वेस्टमेंट में तो हम कोई सरकारी कारखाना खुल गया, एम्स खुल गया, पीएसयू खुल गया, लेकिन प्राइवेट इन्वेस्टमेंट और पब्लिक इन्वेस्टमेंट दोनों से आप जुड़े हुए हो। अभी मुझे बताया संजीव जी ने कि कुछ पीएसयू है जिसमें आप लीगल हेड हो, ऐसा ही है ना, और कुछ आपके जो सरकारी कंपनियां नहीं है, प्राइवेट कंपनियां, उनके लीगल हेड हो। इसका मतलब जो इन्वेस्टमेंट का एक जीडीपी में बास्केट है वो 22 से लेकर के 28% है, उसमें आप पब्लिक इन्वेस्टमेंट से भी जुड़े हुए हो और प्राइवेट इन्वेस्टमेंट से जुड़े हुए। आप जैसा ग्राहक को हम छोड़ेंगे क्यों? अगर हमें जीडीपी बढ़ानी तो आप जैसा ग्राहक हम कैसे छोड़ेंगे? और आप एक्सपोर्ट भी बढ़ा रहे हो। इंपोर्ट माइनस जो इंपोर्ट का आंकड़ा है उस एक्सपोर्ट के आंकड़े से माइनस करने के बाद जो आंकड़ा बचता है उसको हम नेट एक्सपोर्ट कहते हैं। तो उसमें भी आपकी भूमिका है, तो आपकी कंजम्पशन में भी भूमिका है, आपकी इन्वेस्टमेंट में भी भूमिका है, आपकी एक्सपोर्ट में भी भूमिका है, और जीडीपी बढ़ाने में भूमिका है, भारत को विकसित भारत बनाने में भूमिका है। हमारी इकोनॉमी की साइज अभी 5वीं है, उसको 3री तक ले जाने में आपकी भूमिका है। तो फिर आपका जो रोल है जो आपकी डिमांड है वो पूरी करना सरकारों का कर्तव्य बनता है, ऐसा मैं मानता हूँ। इसलिए आज के इस प्रोग्राम के बाद आपको जल्दी कुछ अच्छे समाचार मिलेंगे आपके ऑर्गेनाइजेशन के लिए। बहुत बहुत धन्यवाद। थैंक यू।
Thank you so much, sir. I would like to call upon to give away the memento to Shukla Vasanji. I would also like to call upon all GCAI members to please come up for a group photo as well. We would also like to invite our sponsors for this group photo. Thank you so much, everyone. Thank you.